Good morning, everyone.
Morning, Your Honor.
Morning, Your Honor.
Morning.
Morning, Judge.
Morning.
Hey,
Yeah.
guys.
Good morning.
Morning, Your Honor.
All right. So, can everyone see the screen okay? We have kind of the list of the cases on the dismissal docket starting off. And so if you see your case coming up, please unmute. It'll allow this to go a little bit quicker. And we'll go ahead and get started. Okay, so we're going to start with U.S. National Bank versus Lashonda Fonbula, cause number DC 1920612. Anyone here on that case? Guys, anyone here on that case? Okay. Anyone here on Brittany Wright versus Ruben Hernandez, cause number DC 2000432? Anyone here on that case? Okay. Anyone here on Portfolio Recovery Associates versus Moody? DC 2000445. Anyone here on that case? Anyone here on Portfolio Recovery Associates? Okay. Anyone here on Citibank NA versus Hurd? Anyone here on that case? Just speak up. Okay. Anyone here on DC on Nurez LLC versus Legacy Texas Bank Successor and Interest of Viewpoint Bank? Anyone here on that case? Go ahead and speak up, everyone. Okay. Anyone here on DC 2001145? State of Texas versus 28,005 dollars currency.
Good morning, Your Honor. This is Courtney Parker for the plaintiff, State of Texas.
It's a little hard to hear you. Would you mind speaking up just a little bit? Let me make sure my sound is up.
Can you hear me now?
Yeah, that's better. Okay. What's going on with this one?
So on that one, we filed a default on September 21st on that case.
Let me see. Right. Okay. Rhonda, go ahead and, oh, that was last week. Go ahead and, I will say I just signed a big stack of defaults, so it may be in there, but if not, Rhonda, go ahead and put that on my stack and review it. All right. We'll go ahead and continue it. Let's see. But at the very least, we'll continue it for 2 weeks.
Okay,
But
thank you,
usually
Your Honor.
those are okay. All righty. Let's go to Wheel Pros versus Wheels Outlet, DC 201182. Anyone here on that? Wheels Pros versus Wheels Outlet.
Yes, Your Honor. This is Matt Sapp. I'm here on behalf of Wheel Pros.
Okay, what's going on with this case?
This is just a case to domesticate a federal court judgment from a couple years ago. We had a companion case that was filed against the defendant that was then resolved in about April. I think we filed the judgment in January. So we are just domesticating it, and we've settled that companion case and agreed not to enforce the judgment at this time, as long as the settlement agreement is complied with by the defendant.
So we just go ahead and DWOP this one, it sounds like.
Well, we'd like to keep it at least, I guess, finalize the domestication process so that the judgment is there and can be enforced if the defendant violates the terms of the settlement agreement and we need to actually enforce the judgment. So we don't have to redo the whole process if we can.
When is that going to be done?
He is paying in monthly installments for the next 3 years. And right now we are having some issues with him being behind on payments already.
Yeah, I'm not leaving this open for 3 years, obviously. Why don't we, it sounds like maybe this would be ripe for default or sorry, DWOP at this point, especially if he's already behind. Is there some type of I mean, I don't know why you really even need an open case on this.
Well, with him being behind on the current settlement payments, we'd like the option to be able to enforce the prior federal court judgment against him if need be. He's a Texas resident.
Right, but the court's not keeping you from doing that, right?
No, the court is not.
I mean, so, I mean, I don't know why you really even need this lawsuit because you have a settlement agreement, right?
We have a settlement agreement in a separate case. So this is a federal court case.
I understand that. I understand that. I'm just saying, why do you need this case if you already have a settlement agreement and you're not doing anything to enforce it? I mean, what this lawsuit, the purpose of it is to allow you to enforce the judgment, but you're not enforcing the judgment, right?
We are not per our agreement in the other case, but because the defendant is currently behind, we've got a dispute on whether the payments were not cashed properly or have not been tendered properly that we're trying to work through with him right now. And if it turns out that he has just not been sending the settlement payments as he's supposed to, then we would move forward with enforcing this old judgment against him.
But if we DWOP this one, there's nothing to keep you from filing another lawsuit, right? If you need to.
No, we would just have to redo the process and refile the domesticate the judgment again, Your Honor.
Why don't we do this? I'll give you 30 days, and then if you guys can kind of figure out what you want to do, if you're going to, I'm not going to let this be a placeholder, for the next 3 years. So you guys need to decide if you're going to enforce it or not. If you're not going to enforce it, it probably should be DWOP'd. If you are going to enforce it, that's what I'm here for. But I'm not going to just leave this around for 3 years. So just let me know in 30 days. We'll go ahead and reset this for 30 days.
Okay, thank you, Your Honor.
Thank you. Portfolio Recovery Associates versus Standoak. Anyone here on that case? All right, DC 1914678, Tomika Bonner versus Brown. Anyone here in that case? Okay. Anyone here on Ally Bank versus Valzom Group? Anyone here on that case? Okay. Anyone here on Angel Labor versus Shanta Claiborne?
I'm Corey Kingery here for that one, Your Honor.
Okay.
We had filed a motion for default. I've sent an affidavit to my client to sign to prove up his damages. He hasn't signed it for me yet, but the rest of it's ready to go. As soon as I get that back, I'll just insert it into the PDF and get it filed. It'll be good to go.
You have filed a default or you haven't filed a default?
We have filed a default as to liability, but I need the affidavit from my client to prove up the damages.
All right. We'll give you guys 30 days on this one, but let's try to get it in.
Thank you, Your Honor.
Okay. Costas versus Veritex Holding.
Yes, Your Honor. Kenneth Fair for Pamela Costas.
You'll need to speak up a little bit. You're very, very quiet.
Sure, absolutely. Kenneth Fair on behalf of Pamela Costas.
What's going on in this one?
This is actually related to a very complicated estate proceeding that has been going on in Houston. I'm happy to say that as of this weekend, we've worked out a settlement agreement with among some of the parties, the result of which will be, among a lot of other things, the dismissal of this lawsuit. So if the court would indulge us to just hold this over for another 30 days, I think by the time the settlement agreement is signed and then carried out, by the time that comes around, this case will have been dismissed at that point.
Okay, we'll go ahead and give you 30 days. Good luck with getting everything done.
It's been very complicated, but I think we finally got it. So thank you.
That's good to know. Good to know. Congratulations. All right, thank you so much. DC 10135, State of Texas versus $12,668.
Good morning, Your Honor. So on this case, this is the first setting on this case. This case was filed July 27th. We do not have service.
Okay.
We have issued a new citation to the address on claimant's bond. So we're hoping that that will be a valid address. So that way we may affect service.
How much time do you need?
Can we get 60 days on that one?
All right, so it's so new, we'll give you 60 days.
Okay, thank
So,
you.
All right, thank you. Have a good day.
I have one more. So I'll be
Okay.
on the call.
I'll see you in a few minutes.
Okay.
DC 193401.
Emily
Nick-
Owen. Oh,
Hello,
hi. Emily Owen for the defendants.
anyone here for the plaintiff?
Yes, I'm here. I'm Tamara.
Who? I heard Tamara Brock, maybe. Is that the plaintiff's attorney?
Yes.
Okay. What's going on in this case?
Your
Oh,
Honor, it's Rob reading. I'm the guardian ad litem. Can you hear me? Because I don't think people can hear.
Oh, okay.
We have a prove up today at 11:15 in your court on this case.
Oh, okay. I don't know what, there's somebody trying to talk, but I can't hear them. Miss Brock, I think you have a bad connection maybe. But we'll go ahead and just see you guys at 11:15 then, okay?
Thank you, Your Honor.
All right, thank you guys. We'll see you at 11:15. Fifth Third Bank versus Riddick. DC 1914985. Fifth Third Bank, that's a strange name. Fifth Third Bank versus Riddick. Is there anyone here on that case? Fifth Third Bank, anyone? Okay. DC 1920247. That's a weird looking cause number. DC
Your Honor,
19.
This is Jason Smith. I'm for the plaintiffs in this case.
Okay.
We have filed a motion. This is a car wreck. We have served the defendants. It's one of those situations where the insurance company, Amax Insurance Company, I'm not sure if you've heard of Amax, but they surprisingly aren't accepting any role in this. And so we've been trying to delay to get them involved, but we have filed a motion for default and I've requested a hearing. I don't know if you're doing it by hearing or affidavit. And I wish I had a good joke to invoke the memory of David Weiner, but I don't.
No, that's so sad. That is so sad.
Funny guy, great lawyer.
Yeah, I agree. He, when I was a brand new lawyer, I worked with Wendell Turley and I spent a lot of time in the library, and he was the appellate lawyer, and he and I would talk, and anyway, just a wonderful guy.
Yep, I didn't
Very,
realize.
very sad.
He was-
Well, on this case, the Waits case, typically, if you're just seeking, for example, your medical expenses to be paid, you can do those via affidavit. But if you want pain and suffering, typically I require the plaintiff to testify for that. What is your kind of preference on this one, Jason?
If there would be some pain and mental anguish, Your Honor. So if
Okay.
I could ask the court to set this for a default hearing on the damages and enter the default on the motion that we filed.
When would you like to do that?
When do you normally do, what time, any particular day of the week that you
Usually Mondays, but we do them Fridays too. Do you know your client's schedule? Is your client?
My client's work, but could we do it on October 26th, Your Honor?
October 26th. Sure.
Okay.
So we'll set this for default and DWAP on December 26th. On October 26th. Sorry.
I'll send out a notice to the defendants that we have served, as well as AMAX Insurance.
Hopefully that'll get them to pay attention. And sometimes that works, sometimes it doesn't. So, and I'll always allow you to aggressively enforce those types of judgments. So, anyway, so, but we'll go ahead and set it, Rhonda, go ahead and set it for default on October 26th and DWAP at 9 o'clock that morning.
Thank you, Your Honor.
All right, thank you. Bye-bye. Good to see you.
Good to see you.
I think our next one is Overstreet versus Greer.
David Maldonado for the plaintiff.
All right, what's going on with this one?
So this case is settled and everything is finalized. We're just waiting to receive the check from the defense attorney.
Okay. What do y'all want to do on this one? Do you want to just kind of wait, or?
Yeah, can we just have a 2-week extension? That should be plenty of time.
Okay. All right, we'll give you 2 weeks. And that was Overstreet,
Thank you,
right?
Your Honor. Correct.
Okay. Great. Good to see Mr. Maldonado.
Thank you, Your Honor. Good to see you as well.
1920368.
Courtney Parker for the plaintiff, state of Texas.
You have a lot today. So what's going on with this one?
So on this one, we cannot get the claimant served. So you can go ahead and dismiss this one. And if we
Okay.
get him served within the 30 days, then we will reinstate the case.
Okay. All right. Thank you.
All right.
Have a
Thank
good day,
you.
Ms. Parker.
You too. Bye.
Bye-bye. I don't think this one is supposed to be on our DWAP docket, but DC 209166, Stir Dallas versus Abbott. Anyone here on that case? Stir Dallas versus Abbott. Rhonda, do not dismiss this one. I don't think it's supposed to be on the dismissal docket, actually. Go ahead and just move it 120 days on the DWAP. All right. Department Stores National Bank versus Bailey. The case has been around for a while. Anyone here on that case? Is someone trying to talk? I hear a noise, but I can't hear it. Is someone here for that? I hear a electronic sounding noise. Anyone here for that? If you're here for that, go ahead and write something in the chat because I can't hear. Is there someone here for that? Go ahead and, if you're here for that, I feel like someone's trying to talk, go ahead and call Rhonda and let her know. McBurney versus Boyd, cause number DC 174694. McBurney versus Boyd. Valiant Professional Services versus Lugo, DC 1515916. Anyone here for that case? Okay. Ally Bank versus Flores, DC 1917016. All right, anyone here on the DWAP docket that I haven't talked to yet? Anyone here on the dismissal doc that I haven't talked to yet? Go ahead and speak up. Okay.
Anthony Clarkson.
Okay. What case are you here for, sir?
I was here, the one that got sent out originally, it was number 17, DC 2008-985, Donnell Porter et al. Versus Deborah Bird Jackson. I had spoken with the coordinator on Friday, talking about getting service on an out-of-state defendant, and she had said that she was going to move it at least 30 days. So I just came on as an abundance of caution, but I see that it's not on here. So
Yeah, she has the ability to reset any case 30 days on the first setting. So if you were here on that, then but anyway, so you're being careful, which is fine, no problem. And have a good day. Okay.
Thank you, Your Honor.
Anyone else here on the dismissal docket that I haven't spoken to yet? All right. Sanchez versus Doe. Is anyone here on that case?
Jonathan Davenport is here for defendant Ridgemont, who is also the movant.
Stephanie Banish for the plaintiff.
Okay.
Macon.
All righty. Are you guys going to want a record for this? Usually we don't on summary judgment, but if you want, you can have one.
Only to the extent of our objections, Your Honor.
Okay. We'll just go ahead and do this on the record then. Ms. Banish, if you can go ahead and announce the case name and the cause number, we'll go ahead and get started on this hearing.
Okay, I'm Stephanie Banish here for the plaintiff, Elazar Sanchez. And this is versus Macon Inc., Jose Frere, and Ridgemont. The cause number is DC 17-07604.
Who else is here on that case?
Scott Reeve is also here on that case, Your Honor, as well as I.
You're representing Ridgemont?
I represent Ridgemont. Mr. Reeve represents Macon.
All right, let's get started.
All right, thank you, Your Honor. Your Honor, just a little bit of background on this case.
And I've read all of this, so just, you don't need to go into a whole lot of detail, but whatever you feel like you need to.
Okay. Well, just briefly, Your Honor, because I'm not sure how clear it is from the records, but the actual injury in this case occurred when a forklift operated by Jose Frere, who is a defendant who has not appeared, reached over two girders to pick up a third girder. With it, the plaintiff was then in the process of, depending on whose testimony you believe, rigging or not rigging to be set upright. And I just tell you that, Your Honor, because it's relevant to the response filed by the plaintiff. As Your Honor may recall from a motion to compel hearing we had some time ago in which we briefed and kind of opened to the summary judgment. This case, my client is the general contractor in this matter. The injured party worked for Macon, the subcontractor with whom we subcontracted. There are two primary driving issues with respect to this motion. One, the contract that we had with the owner is what you're going to hear today as an upstream contract. Now, there's a Dallas Court of Appeals case, Gonzalez versus VATR Construction, that holds the premise that an upstream contract cannot be relied upon by a plaintiff opposing summary judgment. And if you've read the response filed and the reply filed by us, Your Honor, as well, you'll see that the entirety of plaintiff's argument is a reliance on upstream contract.
I disagree with that. There was a lot of other testimony that was given in this. I don't think it was she was relying solely on that. Is that right, Ms. Spanish, or not?
Yes, Your Honor.
Well, Your Honor, to that point, and I'm happy to go through each and every piece of testimony she's offered, even though there's objections filed to each, but each of them, almost all of them, to be fair, Your Honor, rely on the safety provision of the contract between Ridgemont and the owner. There is testimony about hypothetical questions about what would you have done. Those aren't competent summary judgment evidence. But since Your Honor brought it up, I'm happy to go through it. So, and I don't know how you want to take my objections, Your Honor, if you want me to argue with the
Did you provide a checklist order for the objections?
I did not, Your Honor.
All right. that makes it almost impossible for me to rule on them, especially virtually.
Well, I think you can rule on the real objections stem with respect to the expert reports they filed, and those are pretty easy to rule on because they're unaccepted hearsay. She filed four expert reports as evidence combating my summary judgment, and those are clearly hearsay under the rule. There's no exception to them. They're out-of-court statements being used to offer for the truth of the matter asserted. So, I mean, I think Your Honor can make a global sustaining of our objection as to the expert reports that were offered by Mr. Watson, Mr. David, and Mr. Hayslip. I'm not sure if I'm saying his name right. But those are pretty easy, Your Honor, because again, they're hearsay. They've just attached an affidavit that's not a business record affidavit, just saying, hey, I did this report. And then said, look at the reports. I mean, that's clear hearsay. It's not competent summary judgment evidence. But we've also
saying that affidavits aren't competent summary judgment evidence?
No, Your Honor, I'm saying the affidavits they filed, all they say is, hey, I made this report. They're not business record affidavits. The affidavits don't incorporate the testimony. They don't have the testimony in them. They just say, I did this report. Go take a look at my report. And then they attach the report to the affidavits. That is clear hearsay. And we have objections in addition to the based on factual legal conclusions to the reports that were attached. But I don't think you even need to get there, Your Honor, because again, just saying I did this report and go look at it, that is clear hearsay. They didn't incorporate it into their affidavits. They didn't put the testimony in the affidavits, and the affidavits that are attached don't say or set forth what those opinions were. They just say I did this expert report, and the expert report is attached as Exhibit A to my affidavit, without even complying with. If you want to argue that it was a business record, that this expert somehow keeps his reports as part of his due course, they didn't even do that. So again, the expert reports are hearsay.
Mr. Banish, let me hear your response to that.
Okay, Your Honor, these are the affidavits for summary judgment evidence do not have to be made admissible as business records. Affidavits are competent summary judgment evidence, just as defendants relied upon in their traditional motion for summary judgment where they attached affidavits. It follows and fulfills all the requirements for the declaration to be admissible as summary judgment evidence. It states that they are competent to make the declaration, that it's within their personal knowledge, true and correct. It incorporates the reports that it attaches. It does not need to regurgitate everything or cut and paste into the affidavit itself. It is proving up the affidavits that are attached or the reports that are attached, giving their opinions.
I'll be honest, I really haven't seen anyone, I'm not saying it's incorrect the way it was done, I just never seen anyone do it this way.
And Your Honor, our affidavits are not in any way, shape, or form similar to hers. The affidavits we have offered have the actual testimony upon which we're relying in the affidavit. That way, you know it's a sworn statement. The sum and substance of her affidavits, or excuse me, each expert's affidavits say, attach this declaration as Exhibit 1, a true and correct copy of the report I prepared on August 25th, 2020, containing my opinions in this case. I would have less of an argument if they just incorporated the opinions into the affidavit, but they didn't do that. The expert reports being attached are hearsay.
Well, okay, so I'm looking, for example, I guess at the affidavit of David, it says attached to this declaration, Exhibit 1 is a true and correct copy of the report I prepared on August 25th, 2020, containing my opinions in this case. Exhibit 1 is hereby incorporated herein by reference in its entirety. Statements containing Exhibit 1 are true and correct and within my personal knowledge.
It's a hearsay document, Your Honor. That's exactly what that report is. A hearsay document.
It doesn't need to be any more clear than incorporated herein by reference in its entirety, making it part of this. This is all one and the same. This declaration with the attachments to it are all one document.
I simply disagree, Your Honor. It's unsworn testimony that is a report written sometime prior, and it's being offered for the truth of what it is. That is the definition of a hearsay document.
Do you have any case law on this? I mean, obviously, as we all know, I mean, I've reviewed thousands of summary judgments. You have affidavits attached to them all the time. I've not seen this particular format, though I kind of agree with Ms. Banish. If you're going to do it, I don't know how else you would do this.
Your Honor,
Is there any case law that says that this format is incorrect?
no, but they have the burden to prove that it is a permissible format. And more importantly, Your Honor, if you just look at it this way, these expert reports wouldn't be permitted at trial. They can't be competent summary judgment evidence if they're not admissible. At trial.
Right, but neither would affidavits be admitted at trial, right? I mean, but it's a different format for summary judgment. I mean, most of the summary judgment evidence that I've seen in summary judgments wouldn't be admissible at trial because you can't usually admit affidavits unless they're business record affidavits. And so I don't find, this is what I would suggest just on that point. If you want to do some research about this particular issue, about whether or not you can incorporate by reference an expert report and attach it to a summary judgment, I've never seen any case law on that one way or the other. I tend to think that if it's allowable, Ms. Banish has done it correctly. If it's not allowable, then I just haven't seen case law either way on that. So,
Your
so
Honor,
we could-
I'm sorry.
Go ahead.
I couldn't point you to specific cases at the moment, but in abundance of caution, before filing this, I hired an appellate counsel, Morgan McFeeters, to ensure that everything was admissible. And she researched and drafted the declaration for me specifically based on her research. So I could get that from her and show the court if that's necessary. But she researched and felt very confident that this was.
But you don't have any of her case law on that with you, or?
The briefing, we did some emails back and forth, but I couldn't present it for you right now. I would have to ask her to.
Mr. Davenport, what I would suggest is either we reset this and you can provide case law and she can provide case law on this issue, or I'm going to deny it and we'll just go forward. I mean,
And
conceptually, it kind of makes sense to me that you could do it this way, but I agree with you. I haven't seen it done this way before. And so I want to give everyone an opportunity to, be fully prepared for this. When is our trial setting on this case?
November 17th, I believe, 16th. Is that right, Stephanie?
I don't know off the top of my head. I would say it's in November.
Yeah, I mean, it's unlikely. We'll be getting trials soon, but I don't know that we'll try this case in November, but.
So, Your Honor, though, I think even if you were to take the expert reports out, which they are proper, but we have so much evidence in there, I'm not even relying on those. This is a traditional motion for summary judgment. They're saying we don't have evidence or that they proved conclusively they did not have control. We have deposition after.
Well, so Ms. Banish, do you want to go forward and withdraw the affidavits, or do you?
No, because in abundance of caution, I mean, I threw in everything I could, but I feel like we have ample evidence to dispute their prima facie evidence of an affidavit stating that they didn't have control. I mean, we've got the corporate representatives, the foreman for Macon saying they controlled everything. So it should be.
I've read it all. I tend to agree with you, but I want to make sure that Mr. Davenport and you have every opportunity to make your arguments. And I agree with Mr. Davenport that I somewhat agree with Mr. Davenport in that I agree that I don't usually see expert reports produced in this way. That doesn't mean it's incorrect. I mean, conceptually, it makes sense what you've done, but if he wants time to research this issue, I'm glad to reset the summary judgment. If you want to withdraw the affidavits, you can. But I'm going to kind of leave it up. If you're not willing to withdraw the affidavits, I'm going to leave it up to Mr. Davenport if he wants to reset the summary judgment or if he wants to just go forward today.
No, Your Honor, I'd like to move forward because the expert reports aside, I just disagree. There is no evidence that's not relying on upstream contracts to prove a duty here.
So you're withdrawing your objection to the affidavits?
No, I'm not withdrawing my objections, Your Honor.
Then I'm going to go ahead and reset this then. I mean, I don't know the answer to your question. I'm asking for additional research. If you're going to continue to move forward, then I'm just going to go ahead and reset the summary judgment.
Respectfully, Your Honor, I don't understand why. I mean, I understand you say you need additional research, but I don't think that precludes us from arguing the rest of our motion.
I mean, you're continuing to make this argument. You don't have any case law on point. Ms. Banish doesn't have any case law on point. I think this is a key issue. I'm not trying to give you a hard time, but you can't have your cake and eat it too. Either you withdraw your objection, or I'm resetting it to give you more time to research it.
I guess I don't understand, Your Honor. I mean,
I apologize. I don't know how else to explain it. I really am trying to be respectful here and give you every chance, but I don't want to rule on something that I don't have case law on. So you're kind of putting me in a situation where you're asking me to rule on something where I don't know the answer to it, and you're not willing to give me the answer. So I've given you time to give additional research on this. And so if you want to continue forward with your objections, then I've asked you to provide me case law on that. You don't have case law. So the way I do this, and this is not the first time I've done this, I've been a judge for 14 years. I've done this many times. I've never had anyone object the way you're objecting, but I'm giving you a chance to provide me additional research so that we can go forward with this hearing. Or you need to withdraw the objections. So if you don't like those choices, then I understand that, but those are the choices you have.
well, Your Honor, you've reset this thing for them once already. We've got a trial setting pending.
Mm-hmm.
I mean, my suspicion is I'm going to get an objection to any kind of reset, which again, I don't think is necessary. I think you can hear the rest of our motion. And if you can rule any way you want on the objections.
You're asking me to shoot in the dark, basically, because I have no case law either way.
Well, quite frankly, I think it's their burden to prove once we've objected that their summary judgment evidence is competent. But nonetheless, we've got other issues to be decided. And if unless the court's going to extend our deadline to file a dispositive motion, then I don't have a choice. I've got to move forward today.
Extend your deadline. You've already filed this, right?
Yes, but I think there was also a hearing deadline, which was moved to allow the plaintiff time to go take all the depositions they wanted to take.
What is your deadline for hearing summary judgment? It's usually 30 days, and you're more than 30 days out.
I don't know, Your Honor, what the deadline was. I know there was a deadline to hear the motion, but this was reset by your administrator in accordance to your instructions from our hearing back, and I think in June. So, I mean, unless Ms. Banish is going to waive any objection to resetting this on a timeliness deadline, then, and if she's willing to do that, then I guess I can go pull some case law. But again, these aren't the limitations of my objections. And quite frankly, I don't think even if their expert reports are admissible, they can prove their case.
So then why don't you withdraw your objections?
Because I think their summary judgment evidence is wholly improper, Your Honor.
Okay. And what is the deadline for you to file or to have this heard?
I just pulled up our agreed scheduling order, and it says that deadline for dispositive motions is October 9th. And the trial
Is that to hear them or file them?
I don't have that in my calendar. It just says dispositive motion deadline.
October 9th. Do you want to go ahead and reset this to October 9th? I mean, if this isn't a big deal to either of you, then I'll just go ahead and go forward. But I don't know the answer to this, and no one has provided me case law. And so it's not my burden to do y'all's job. I'm not trying to give you a hard time, but I'm trying to give everyone an opportunity to provide me case law so that I can make the right decision on this. And no one has any case law for me. And so I'm giving you guys an opportunity to find case law and provide it to me so that I can make an informed decision. That's all I'm trying to do. So,
Your Honor, what about this suggestion? We proceed with the motion, and then you give us, I don't know, 7 days to submit case law on the issue of the expert reports.
What do you think of that, Ms. Banish?
I would be agreeable to that.
All right, let's go ahead and finish this up.
Okay, thank you, Your Honor. Your Honor, so putting aside the expert report issue, the only other thing offered to combat the two affidavits, not only from my client, but also from Macon. We've attached an affidavit from Macon's former principal, who testifies in his affidavit that not only did we not control the means and methods, but we didn't supply them with any tools or tricks or trades, and we weren't in charge of safety. But to combat that, the plaintiff attaches several incomplete deposition questions and answers. First off, Your Honor, as we briefed in our motion, there's Gonzalez and then there's the Redinger case from the Supreme Court, which talks about the fact that safety cannot be assumed. And this kind of is buttressing on all of the case law that's cited, but
Well, why don't we do this? We're running out of time on this. I'm going to give each side 10 minutes. So Ms. Munder, can you go ahead and keep time for the next 10 minutes? And Mr. Davenport, you have 10 minutes to finish up your argument.
Thank you, Your Honor. And just for the brief purpose of the background, the Redinger case says it's not enough for a general contractor who has merely a general right to order the work stopped or resume, or to inspect or progress, or to receive reports to make suggestions, recommendations which need not be followed. So that's setting forth that merely having a generalized view and a generalized overview and a generalized responsibility for safety is not enough. So going through each of the deposition excerpts offered by the plaintiff, the first, all of them under Crossan, Your Honor, with the exception of one, Redinger would say not applicable because it's a generalized view of safety. They just ask, are you responsible for safety? And not only is that relying upon the upstream contract, because the contract, which is attached to the affidavits in our motion, between Ridgemont and Macon expressly states that Ridgemont is not responsible for safety and that Macon assumes responsible for safety of their workers and all those that are working for them. In addition to Redinger applying to nearly all of the Ridgemont deposition testimony, plaintiff attempts to rely on a couple of these questions, which are hypotheticals, which would be improper because these guys were not offered as experts or corporate representatives for the purpose of which they were being asked. For instance, on the deposition cited under Joe Crossan, starting on 3615, the question says, if you would have noticed, that's a hypothetical. And even if the question is sufficient, even though there was an objection, Redinger again states that generalized responsibility for safety does not mean that we've assumed a duty. Same would apply to 3713 deposition exhibit from Crossan. The other one from Crossan is 4021, and it's a post-accident question. So here the plaintiff's attempting to argue that a question about post-accident actions can somehow establish a duty pre-accident, which of course is improper. And there are several of these, Your Honor. I'm just trying to kind of skim through them. And we've noted in our reply underneath each of these where it's relying on an upstream contract or the other basis for which we object to the use or believe them to be improper. Then there is the testimony of Claudio Sanchez, who was Macon's foreman. Plaintiff offers deposition testimony in which she asks him if would you consider him to be the boss? Yes, sometimes because we were doing the jobs, but sometimes we don't, we were doing it wrong, and they would tell us what to do. What plaintiff didn't offer was my cross-examination of him, in which he states all of that was reference to safety. So all of the long and short of it is this, Your Honor. All of the testimony offered by plaintiff in response to our summary judgment is about safety. Safety was Macon's responsibility contractually. There is no testimony that we assumed the responsibility for safety other than that we would have general oversight of the project. If we saw them doing something wrong, we would tell them, hey, you need to do this. That is not the kind of assumption of control that any case law stands for that would then establish a duty. And the plaintiff also cited Lee Lewis, which is a wholly different case in its application. In Lee Lewis, the general contractor not only took control of safety, they established particular safety parameters for which the subcontractor was used, which is not present in this case. In fact, in the concurring opinion, the Supreme Court even cites that The contract between the subcontractor in that case and Lee Lewis required them to not only abide by governmental safety rules, which is a standard provision, but also the general contractor's safety rules, which isn't present here. And it also gave them the specific contractual right to remove anyone who failed to comply with safety. Those facts don't exist here. That contractual provision doesn't exist here. All of the reliance on the plaintiff's attempt to keep Ridgemont in this case are relying upon the contract between Ridgemont and the owner. And safety is the sole basis for which they're trying to keep us in. It's not, there's no testimony. There's not even any attempted testimony on the idea that we took control of the means and methods of the subcontractor. We did not. That's not present. It's not even claimed. So it's all relates to safety. And the reliance upon safety is relying upon the upstream contract with the owner, because the contract with Macon very clearly establishes and delineates safety as the responsibility of Macon. And Your Honor, I'll reserve a couple of minutes if you don't mind to respond to Mrs. Banish.
Okay. Let me just ask, Ms. Pettit, are you there? Ms. Pettit, are you there? Okay, she may not be there. She's on the next.
Hi, Your
hearing.
Honor, I'm here. I
Oh.
was trying to find the unmute, but I'm here, Your Honor.
Do you guys still need your hearing at 10, or are you letting us know that you don't need the hearing?
We do still need the hearing, Your Honor.
Okay, all right. So I just gave them a time limit. I was going to waive it if you guys didn't need your hearing. So, all right, Ms. Banish, you have 10 minutes.
Thank you, Your Honor. Okay, so under Texas law, there's two ways that we establish the control of the general contractor over the subcontractor, making them responsible for injuries that could be caused to the subcontractor's workers. And that's either through a contract or through actual control. In this case, we have both. First is addressed on page 7 of our response to summary judgment, and is attached to summary judgment evidence. We have the contract between Ridgemont and Macon, where it specifically incorporates and states that the contract documents for the subcontract agreement consist of the prime contract between the contractor and owner, including any conditions set forth therein. So they keep talking about an upstream contract.
Ms. Banish, you muted yourself. You're unmuted.
Okay, how long ago was I muted?
No, just a second ago, just for a second.
Okay, sorry. So it specifically incorporates the prime contract into the contract with the subcontractor. So it's not an upstream contract to begin with, but it explicitly states that Ridgemont shall supervise and direct the work on the job site, and that Ridgemont expressly assumes full responsibility of the safety of all persons on the job site and shall maintain complete supervision and control over its agents. Not only does their contract state that, but their corporate representatives stated that they did in fact do that. That yes, they did supervise and control Macon. It further states that they assume full responsibility for the safety of all persons employed or utilized under contractor's control or supervision. And then right after that, it defines who the contractor controls and supervises. Shall maintain complete control and supervision over the contractor's agents, employees, and subcontractors, emphasis added. And that the contractor shall supervise and direct the work and have control over construction means, methods, techniques, sequences, and procedures, which their corporate representatives said that they did in fact do. So we've got the contract and then we have their actual control on the job site. Skipping over to the next issue, even if we didn't have this contract, which we do, Ridgemont exercised much more control than they like to admit. Although many representatives were coached carefully not to say that they controlled the specific means and methods, the foreman, Claudio Sanchez for Macon, so the subcontractor's foreman, the one that was there every day over this part of the job for Macon, said that the superintendent for Ridgemont was there all the time and always checking on him and telling him what to do. He did not say just for safety. And even if he did, still they are in control of safety. And it was big, major safety issues that they knew about. Their superintendent said they had issues with Macon on a weekly basis and would tell them over and over to, you know, you need to have your parameters up, you need to do this different. And they just kept on having safety issues regardless. Okay,
The person who was that was operating the, I think it was a crane or forklift, was that person a Macon employee?
Yes.
Okay.
Yes. And so they had all these, Ridgemont's trying to focus you on the driving of the forklift driver and is totally ignoring the bigger issue, which was that they had these huge girders. They're 50 foot long, 6 foot high, and 11 inches wide, so very narrow and tall, lined up at least 10 in a row like dominoes. And that they left him there for days unbraced, which everyone admitted was extremely dangerous. And Ridgemont was in control of the safety of the job site and had an affirmative duty to do something about those huge safety issues, and did nothing. But anyway, we're back on control. So Joe Crossan, the superintendent for Ridgemont, even says, yes, if I see them doing something that they're not supposed to, then I can instruct them not to do it. That shows control over means and methods. The courts, the case law that we cited and the case law that defense counsel cited all says that once the general contractor exercises sufficient control over what the subcontractor is doing, that the subcontractor is not completely free to do how they want, then that creates a duty to do it reasonably. And we have lots of witnesses' testimony that states that they were not free to do as they wanted, and that if Macon did something that Ridgemont didn't like, then they could stop their work, they could instruct them to do different, they could retrain them. They had lots of control over them. And so I think that Claudio's testimony is very important, because he states that not only was the superintendent just walking the land and occasionally, saying hi or let me see what the progress is doing, that he was watching everything. He said he would come by. Let's see the exact quote, but he would say, yes, he'd be coming by, yes, every hour, every 2 hours, every minute. Like, this guy's there constantly. And if he didn't like the way y'all are doing something, would he tell you? Yes, they're always telling us what we're doing wrong. And sometimes, when we're not doing something wrong, they have this safety guy on site and he's in charge of us, or charged to let us know exactly what we're doing. And if we're not doing things correctly, how we're supposed to do it, they fire us. And he said, it went on to say, Joe, whenever he didn't like something, would he tell you to fix it or change it? Yes. And sometimes they wouldn't even notice they were doing something wrong, meaning they're doing a method one way, and that he would come out and say, no, do it a different way. He said, checking everything. This is just a summary judgment motion, and they have the burden on it. But contrary to the 2 affidavits they submitted with just blanket statements that they did not have a contractor control, there's ample evidence suggesting otherwise, creating at least a fact issue. Let me see.
Ms. Munder, how much time does she have left? Okay. You have 3 minutes left.
Okay. So another thing I wanted to point out from the onset, they filed this as a traditional motion for summary judgment, and they state that they're entitled to summary judgment because they did not have a contract with the plaintiff himself or control or exercise control over what the plaintiff was doing. And I wanted to point out that that is not the question. The question is, did they exercise sufficient control over Macon, making them responsible for injuries caused to Macon's employees and workers? And absolutely they did. I'll go ahead and I'll say whatever time I have left. You can go ahead and rebut.
Okay. Mr.
Thank you.
Davenport.
Thank you, Your Honor. A couple of quick points. One, counsel cited testimony about safety responsibility from the prime contract, which is the upstream contract, for the proposition that we held control. Again, Gonzalez, and even a recent Dallas Court of Appeals opinion in 2018, Arana versus Figueroa, 559 Southwest 3rd, 623, again says you cannot rely on upstream contracts to establish a duty. Your Honor, attached to our motion, instead of reading it for you, because I know you've got other things to get to, we attach the contract to the affidavit of our client. And on page 13 of the subcontract between Ridgemont and Macon, 9.4 discusses safety. And what it says is Macon's completely and totally responsible for safety.
How do you rebut the testimony of what's his name, Mr. Claudio or Claudio or?
I was getting to that, Your Honor. I believe you'll, well, the full testimony of what he said. I asked Mr. Sanchez, I said, at the beginning of your deposition, you said that Ridgemont personnel would tell you how to do your job and correct you. You were talking about safety issues, correct? Answer, yes. Did anybody from Ridgemont ever tell you how to erect steel? Answer, I mean, they hurried while sending us, blah, blah, blah. I mean, it's kind of, so I clarified the question, but did they tell you how to rig up and erect steel? Did they? The answer was, they did not tell us how to rig steel because we are the iron workers. I mean, we're supposed to know how. Again, the entirety of their argument rests on the idea that because the prime contract obligates us to be responsible for safety, that means any act of oversight, and somebody's volume's up.
Yeah, I think so.
Any act of oversight makes us, establishes a duty. Gonzalez, Araha, and Aradha clearly state that's not the case. And more importantly, if we're relying on the actual contracts, we're not responsible for safety. Macon is. There is simply no evidence to establish that we are responsible for safety, that we control the means and methods, and the case law is very clear. That could not be more clear. We did not assume control practically. It could not be more clear that we did not assume control or anything other than general oversight of safety, which is permissible.
Whoever's sound that is needs to mute it. It sounds like there's somebody playing music or something.
I'm finished, right?
Okay. Ms. Banish, did you want to say anything else? Ms. Banish, are you there?
Sorry, I was on mute. Okay. Your Honor, yes, just pointing out again that Ridgemont keeps trying to rely on the portion of the contract between Ridgemont and Macon, that it included a summary judgment evidence, but it did not include the full contract documents, which included the prime contract between Ridgemont and the owner. Can you hear me?
I think it's Mr.
Are you there?
Could you hear me?
I can. Yeah, go ahead.
Could you hear me before?
Yeah, kind of. Somebody's
Over the
music is
music.
playing.
Okay, so I was just pointing out that they didn't include the full contract documents, which are defined in the contract between Ridgemont and Macon, which says that it includes, and there's even priority to the Ridgemont and owner contract, which is incorporated as their documents. And we did attach that to our response for summary judgment as evidence. And so it does show, you can see that it incorporates it, and then you see the very specific language that gives Ridgemont the affirmative duty and obligation to control and supervise the site and be responsible for safety of everyone. And even, even if we didn't have all of that, which we do, we have lots, but even if we had just Claudio Sanchez's testimony, we have enough summary judgment evidence that the court needs to deny their traditional motion for summary judgment, because the guy out there on the ground in charge of Macon talked about how much control was exerted over them every day by Ridgemont.
Thank you, Ms. Banish. Thank you, Mr. Davenport. As we discussed earlier, you guys are going to provide me additional briefing on that expert report issue. And after I get that, I'll make a ruling. All right. Anything else, guys?
Not today, Your Honor. Well, Your Honor, one quick question. When do you think the court might have an idea as to whether or not we're actually going to trial in November?
We're having a meeting this Wednesday. There's a plan that's being discussed to start up jury trials in November. I don't know if that's going to be approved by the judges, but it's been submitted to we have a subcommittee of judges that just met on it, and there was disagreement in that group, and now it's being submitted to the judges as a whole. So we're going to be voting on Wednesday, but potentially jury trials could start as early as November. So I would be a little surprised if this case went to trial, but it's not beyond the realm of possibility.
And Your Honor, just to clarify, so we're going to submit case law supporting our positions on the expert reports. And so if we just need to e-file that maybe by Friday, and then we can get a ruling by the
Why
court.
don't, Mr. Davenport, since you're the one who's made the objection, why don't you submit your brief by, say, Wednesday? Would that work for you?
I'm sure we can accomplish that, Your Honor.
And then Ms. Banish, if you could get a response by Friday.
Thank you, Your Honor.
Thank you, Your Honor.
All right, guys, thank you so much. You guys have a good day, okay?
Thank you. You too. Bye-bye.
Okay, good. We have a lot of stuff set at 10. We have a room full of people. I'll go ahead and start with Tracy Young versus Davila. I think that'll be the shortest hearing. Anyone here on that case?
Yes, Your Honor, this is Young Jenkins.
Okay.
I'm here for Stephanie Rima, defendant.
Okay, what's going on with this one?
Looks like it's a newer case. It's from June of 2019 or 2020. So it's a status conference. I don't know the details. Ms. Rima is actually in another hearing and emailed me for coverage. So I just kind of jumped in.
The main reason for this hearing is just to pick a trial setting. So when you're the only one here, is anyone here with the plaintiffs on that case, on the Tracy Young case? Anyone here? Okay. When would you like to set this for trial, Mr. Jenkins?
At least 9 months out, if you don't mind. Usually, ideally a year from the filing date. That's about
So
it.
sometime maybe in the summer?
That'd be great.
July 13th, 20th, 27th, August 3rd, 10th. What is your thought?
I'll defer to you, Judge. All those are fine.
Let's go ahead and set it on July 20th, if that's okay with you.
Sounds great.
Rhonda, go ahead and set this case for trial on July 20th. All right. Anything else we need to chat about, Mr. Jenkins?
No, Your Honor. Thank you very much for your time. Appreciate it. Maybe excuse.
No problem. You have a good day.
You too.
Next, we have the summary judgment involving Zubarak versus Gonzalez. Are both sides here on that case? Anyone here on that case? I'm sorry?
Robert Miller on behalf of Mr. Zubarak. We're here.
Morning, Your Honor. Greg Fell on behalf of two of the defendants, Francisco and Marianne Gonzalez.
Kelly Milligan here for defendant.
I'm sorry, Mr. Milligan, you said you were here as well?
Yes, for defendant Ronnie Henderson.
Okay.
Your Honor, Braulio Gonzalez for defendants Smelser, Sorensen, and Phillips Amended Trust.
Okay.
Good morning, Judge. Britt Bizey for the Valley View Park Estates Homeowners Association. We're a third-party defendant.
Okay. Anyone else here on that case?
Casey Myers, I'm also on behalf of Valley View Park Estates, but I believe Brent Bies will be handling the argument primarily on the association's behalf.
Okay. Do y'all want to, anybody want a record for this?
Yes.
Okay. Let's do this. Let's go on the record, Tony, on cause number DC 1918220, Zubarak versus Gonzalez. Counsel, make your appearances.
Robert Miller on behalf of plaintiff Charles Zubarak.
Greg Fell for the defendants, Francisco Gonzalez and Marianne Gonzalez.
Kelly Milligan for defendant Ronnie Henderson.
Braulio Gonzalez for defendants Smelser, Sorensen, and the Phillips Amended Family Trust.
Brent Bisey for the Valley View Park Estates Homeowners Association third-party defendant.
Casey Myers on behalf of Valley View Park Estates Homeowners Association.
Is that everyone? Okay. Let's go ahead and start with the summary judgment. And I have read everything and I do have some questions, but we'll go ahead and let you guys get started.
Since it's my motion, Your Honor, I will go first. This motion for summary judgment, there's really a very large question of law for the court to decide, which is, may the board of directors, the ACC, grant an owner to build something that is clearly and unambiguously prohibited by the declaration. In the motion for summary judgment, when it was filed, it was stated that certified copies of the declaration could not be obtained due to the pandemic. The certified copies of the 2012 declaration and 2018 declaration clearly state that no structures may be built in the easement. Article Roman numeral 11, section 1, all streets and alleys and easements shown on the recorded plat of the development have been reserved for the purposes indicated. So you also have Article 10 states, if found not to be in compliance with this amended and restated declaration, and that's plans and specifications, shall be returned marked disapproved, accompanied by a reasonable statement of items found not to comply with this declaration. As a matter of law, they should never have granted any approvals. It all should have been stamped, does not comply with the declaration. And that's a question of law for the court.
You do this. I'm having a little bit of problems pulling this up off of the county's website. Can you go ahead and share screen the exact provision? I've read it, but I'm going to want to talk with all the different parties about it. So can you share I think out of the declaration you're relying on?
I can, Your Honor, I think. Did that do it yet or not?
No, I've enabled it, so you need to share screen it.
Is that showing anything yet, Judge?
No.
Okay, hang on for just a minute. Let me go back to the Zoomy thing. I'm trying to find out where I can share the screen. Share content, that's what I was looking for.
It'll be on the bottom. It says share screen. You just click that and then go to the document you want to share.
Okay. Did that do it?
No.
Oh, dang. Hang on, Judge.
Can anyone share screen it? It seems like we're having a little bit of technical difficulties.
Did that come up?
No.
No?
Anybody on this case, can they share screen that provision? Casey Myers, okay.
There we go. It works.
Sorry.
Did you share screen the provision I was asking for?
I can do it. What specific section, Robert Miller or Mr. Miller?
Article 12, Section 3. Well, just a minute. Was that the last one I was talking about was Article 10?
The one that says they can't do it. I want that section shown. That says you can't build in the easement, basically.
Which section, Mr. Miller? And I can pull it up.
Article 11.
Article 11.
Section 1.
Section 1.
Mr. Meyer, are you able to do that? There you go. Okay. So the key section to this, to me, seems to be no owner or occupant may erect any permanent structure of any type whatsoever in these easements. So Mr. Miller, you seem like you're having some technical difficulties. Let me just hear from the respondents. How do you get around that statement in Article 11? Anybody is there a way to get around this or not? Should I just grant summary judgment?
Well, Judge, I'll jump in here. You know, I understand you're wanting to get right to the declaration, but I think all the defendants, certainly I have, raised quite a few objections to the so-called summary judgment evidence. Specifically, Mr. Miller did not seek leave from the court to late file the certified copies. This motion was filed about, gosh, what, about 4 or 5 months ago now, with uncertified copies.
Mr. Feld, just answer the question that I've asked, because I think that's the key one. How do you get around that particular sentence?
Well, a couple things. Number one, the association in the declarations, there is a dispute resolution clause that mandates that the parties submit disputes such as this to the board for resolution. Mr. Miller's client did not do that. When this dispute was raised with the lawsuit, we requested it. It was submitted to the board, and the board opined in the minutes that we've attached that the fences were not in violation of the declarations. That's number one. Number two, as the court knows, I know you mentioned that you're familiar with HOA disputes having maybe
very familiar with them. Yeah.
Okay. Well, you know, the property code has a presumption that the HOA's interpretation of restrictive covenants are presumed to be reasonable unless the plaintiff in this case can show that it was capricious, arbitrary, discriminatory. And in fact, in Mr. Barg's affidavit, he actually makes that opinion that he thinks the decision was capricious, is the word that he used. That's a fact issue.
Okay. Is that it?
No, well, no, that's not it, Your Honor. Number two in our response would be that the easement holders and the beneficiaries of the easement have abandoned the easement long ago. We provided certified copies from the City of Farmers Branch. The city is the one who created the easement, in which
Can you go back to the previous article? So it says all streets, alleys, and easements shown on the recorded plat of development have been reserved for the purposes indicated. No owner or occupant may erect any permanent structure of any type whatsoever in these easement areas. I mean, this is how this development was created. I just don't see if it had said, you know, absent some showing. I mean, this is I assume this was the article that was in place at the time this was brought before the homeowners association, correct?
Yes.
Is that right? I mean, it says you can't do X, and then they allow them to do X. I don't see, there's just no wiggle room here that I can see. I mean, clearly these fences are permanent structures, correct? Mr. Fell?
You're under the board in the minutes pursuant to the dispute resolution that I referenced previously, found that these are not permanent structures as the association contemplated this term to mean in these declarations.
Is there a definition of what a permanent structure is within this document?
And I don't believe there is, Your Honor. I think there may be a definition for a temporary structure, but there is no definition for what compromises a permanent structure.
Is that right, Mr. Miller?
Yes, and it does not consider a fence as a temporary structure.
Where is the definition of temporary structure in the document?
That one I didn't come up with.
It's in Article 9, Section 4.
Article 9, Section 4.
Can I see that? Where's the definition of temporary structure? Is there one?
You had it up there for a minute, Judge. Section 4.
Yeah, it's up there. I just don't see where in here where it's the what the definition is.
I believe those are the only two locations that it actually exists, the words temporary structure. I did a search through the.
Oh, that's pretty cool.
Those are the only locations that exist.
But I don't see that within Section 4 temporary structure is.
It is used right here, and then this is the other location that it's used within the documents. But
No, I'm just saying, do they define what a temporary structure is? That's what I'm asking.
I don't believe so here.
They give some ideas of what.
I don't even see that.
But not really, Judge.
That.
But if you look at the documents that the defendants put in as part of their response, they have the plans for these fences, and they all show that they're anchored, a couple of feet down in concrete. And that's pretty.
If I recall, there's some case law that you guys cite to define what a permanent structure is versus a temporary structure, correct?
Yes, Your Honor.
And fences like this are considered permanent structures, is my recollection from the case law. Is that correct, Mr. Fell, or not?
I believe that's correct, Your Honor.
Okay. Mr. Fell, did you have anything else?
Yes, I would. Again, this remind the court of our objections, and in particular, I don't believe there's any evidence in this summary judgment evidence that these fences are in the easement.
Mr. Miller, is that correct? I haven't really thought about that issue. I assume they were in the easement from what.
From the wall, easement drums.
But is there anything in the summary judgment record that indicates they're in the easement?
Well, it's in Mr. Zubarik's affidavit. He says they're in the easement when he walked around and looked at them.
And that's really one of the things we objected to, Your Honor, is it's a conclusory statement from Mr. Zubarik that they're in the easement. There's no predicate that he's qualified to read the plat. There's no evidence as to what the boundaries are, what the specific conditions of the easement are, and there's no application of Mr. Zubarik's one conclusory statement that they're in the easement.
Is there any, have you presented any contrary evidence?
Affirmatively that they are not in the easement?
Correct.
No.
So the plaintiff is saying they are in the easement, and your side has not disputed that. Is that correct?
Not in response to the summary judgment motion, Your Honor.
Okay.
Objective to the admissibility of that statement. And I think that's the only evidence the court would have before it.
Judge, I believe Mr. Fell actually misspoke. He did controvert in his response brief that the fence is not in the easement. He made that statement actually by making the argument that there is no easement at all by abandonment, because this alleged the alleged violation has occurred in an area which the plaintiff believes easement exists. And the plaintiff is simply making a statement as to where this fence is located along a wall that was built over 2 decades ago that was also presumably within this easement. So fixing a permanent structure and then having a fence behind that permanent structure is what Mr. Fell is arguing is the basis for this abandonment, in addition to the fact that the beneficiaries of this easement in gross, being the utility companies, also permitted any further construction to occur either within that easement or near that easement, anything that could affect their rights as the people that have that easement in gross. So since the homeowners who are the servient estate here, they've erected these fences in an area that it is a major issue of dispute, both on the law and as to the facts, as to whether or not this area is a part of the easement. Now, Mr. Zubarik, in his affidavit, sure, he makes a statement, takes some pictures and posts them to his motion. But the issue with that, Judge, is that we don't know when those photos were taken. We don't know the distance of that fence to the wall in relation to where the easement is. And so the court does not have adequate information as to whether or not summary judgment may be granted. On top of that, Judge, the plats and drawings that are provided, we have no information as to whether or not that's the most accurate rendering of this area. So if the court is going to enter summary judgment here, we're entering summary judgment based off of a plaintiff's self-serving affidavit that lacks the easily attainable survey information and the certified copies. At this point, Judge, I understand in April, certified copies were hard to get a hold of. Things were all over the place. But now, Judge, we're in a situation where it's the end of September. Certified copies are obtainable. The documents that are necessary in order to achieve summary judgment here are not before this court. The plaintiff.
All right. You're just at this point, you're just rehashing what Mr. Fell said. Mr. Miller or Mr. Milligan, did you want to say something?
Well,
Mr. Milligan. Okay, Mr. Miller.
I did want to add a couple of things, Your Honor. First off, is it me or is it Mr. Miller, Your Honor?
Go ahead, Mr. Milligan.
Okay, thank you. Okay. Sorry, train of thought got derailed just a little bit there. Your Honor, I don't think you can grant summary judgment on this record. You can take a look at the language that Mr. Miller is citing, and yet there is plenty of evidence of record to indicate that there is still an opportunity for the board at least to consider requests by homeowners like the individual defendants as to whether building a fence of this sort is proper. Exactly what happened here, Your Honor. If you listen to Mr. Miller's comments when he led off his argument, if you look at his reply affidavit, his real beef here isn't with the individual homeowners, it's with the HOA for going so far as to allow these fences. And if I can quote some language from his affidavit, when he speaks of his injury, the harm to me is the arbitrary changing of the declaration without the 2/3 vote. Or the damage to me and VVPE homeowners is that if a board can change the declaration, then we have no board, we have no declaration, we have no HOA. Am I still here? Are you hearing me?
Yeah.
Okay, very good, because my screen just did something weird and I fear technology. So, Your Honor, this didn't happen in a vacuum. The defendants that Mr. Miller named only built these fences after making application to the board, having that thoroughly vetted and reviewed.
Mr. Milligan, let me just say that, Mr. Milligan, let me just ask this, because you raised an issue that I think was interesting. There's two issues I want to kind of have addressed at this point. One is there anything in the declarations that allows the board to supersede this article? Is there something that says, notwithstanding any other statement within the declaration, the board can consider changes to, that gives them the authority to basically ignore the declarations?
Well, I don't think it's anything worded quite like that, Your Honor, but obviously the dispute resolution.
Why don't you share screen what you believe will give them the authority to do this?
I have no way to do that, Your Honor. My computer is kind of an antiquated piece of junk.
Well, why don't you do this? Why don't you tell Mr. Meyer, who seems to be the only one here who knows how to do this, what article are you relying on so that he can pull it up?
I think we're talking about the dispute resolution provisions that have been referenced.
So I've already heard the argument on that. So no other provision other than that.
No, but I think you also have to look at practice, Your Honor. In the absence of language that says the board can go ahead and approve offense in violation of a certain section, because you're not going to get it that black and white. But the fact is, it's been done before. Obviously, these documents that we attach to our response briefing.
You reference something else that says that the articles can be changed with a 2/3 vote of the board. Is that correct? Or is that of the board or the homeowners association?
Homeowners.
It's in the declaration.
It's in the declaration that you need a 2/3 majority to amend the declaration. It's also
2/3 of what? 2/3 of the board or 2/3 of the
2/3 of the members of the owners.
At any point prior to this lawsuit, has there, or I guess really at any point, did they change that Article 11, or was that in place at the time this?
It's in place since 2012.
It's been in place since 2012.
Okay, so it was not changed?
No.
Okay. All right, Mr. Miller, I want to hear your argument as to abandonment.
Well, if you look at the documents that the defendants gave, which one of them was the city of Farmers Branch saying, yeah, well, you can do this, but this is, and it says this in the document, that this property is an HOA, you better go talk to them. And the city granted the building permit only if they would do a hold harmless. Likewise, the Encore people on page 36 of the defendant's response, they had facilities, and this was not a waiver of their rights or liability of the owner and builder. On page 37, Southwestern Bell said basically the same thing. The only one who doesn't have anything in the easement is on page 38, it's Lone Star Gas. They don't have anything there. So that doesn't matter, but page 39, exhibit 10, to their response, TCI Cable said, okay, but this was not a vacation of their right to use the easement. So I don't know where they came up with this idea that the easement's been abandoned. And as far as Mr. Zubarik walking the easement area, he knows where it is. He made the pictures, and to adopt a picture, you don't have to go through all that stuff about the day and everything else. You have to say, this is a true and correct copy of the area. So there's just no way around. They can't change the declaration.
Okay. All right. So we had 30 minutes for this. So
May I make an argument on that, Your Honor, for a short period of time?
You have 30 seconds.
Sure. Under section 202.006 of the Texas Property Code, a dedicatory instrument has no effect until the instrument is filed in accordance with this section. And Mr. Miller is arguing that the declaration has been amended, and 202.06B states that a dedicatory instrument has no effect until the instrument is filed in accordance with this section. Technically, either the instrument has no effect and he would have no cause of action, or it has, technically the instrument has no effect. His argument on amendment would fail as a result of 202.06B.
I'm not sure I'm following you, what you're saying, Ro. Are you saying that the amendment would fail? I'm not following you. Can you?
Mr. Miller is arguing that the declaration has been amended as a result of the actions of the board of directors. That can't take place specifically because of 209.0041.
Mr. Miller is arguing that?
I believe, from my understanding, he was arguing that the declaration was amended. Is he not?
Are you arguing the declaration? I didn't get that, but are you arguing that?
No, Your Honor. What I was saying is that it has to be amended, and it hasn't.
It has to be amended, right?
So,
that's how I understood it.
Oh, okay. So at that point, otherwise, my arguments would just be specifically related to dispute resolution procedures and the ability of the association directors to decide this matter.
You're not arguing, Mr. Myers, that the original declaration was never filed.
Correct.
Okay.
But at that point, I believed he was arguing that. My full argument would be related to dispute resolution procedure.
I'm going to go ahead and grant summary judgment, probably to no surprise. Do you guys have a order for me?
I do, Your Honor. Now, whether I can get it up or not is another issue. I can submit it, I can e-file it when we're done here.
Is it already been e-filed or no?
It has not, Your Honor.
Why don't you go ahead and share that with all the other parties who are subject to the summary judgment, and then submit that to the court. It'd be great if I could get it by tomorrow, because I'll be at the courthouse tomorrow.
If I e-file it today,
E-file it, so go ahead and e-file it once you've run it by everyone, and email it to my court coordinator.
email to court coordinator, okay.
And e-file, both.
Judge, will there also be a ruling on all of the objections to the evidence that was attached to the motion for summary judgment?
Did you submit an order on that?
I believe all the parties have. I know that we have got one that is pending as well.
Go ahead and submit a checklist order on all of those, and I'll roll in those as well.
Thank you, Judge.
Anything else, guys?
Your Honor, we also have a plaintiff's motion to sever the claim between the defendants and third-party defendant.
I'm not going to hear that today.
Okay.
So we'll reset that until after the summary judgment. All right, anything else, guys?
No, Your Honor.
Okay.
Your Honor, just to make sure, I'll send my proposed order to all the other attorneys.
That are subject to the summary judgment.
Yeah. And
then once you get comments back or whatever, go ahead and submit that to the court. E-file that and email it.
yes, Your Honor.
All right, anything else, guys? Okay, great to see you guys, and you guys be safe out there, okay?
Thank you, Judge.
Thank you, Your Honor.
All right, I think we have the Hume case or home case.
I take it we can be excused, Your Honor?
You are excused.
Thank you.
Okay. Is everyone here that needs to be here for this? I know we have a status conference. We have a variety of other things that are set today on this. Is everyone here that needs to be here for this case?
It appears that way, Your Honor.
Looks like it, Your Honor.
Okay. So we didn't need to have Mr. Buchanan here for this?
I don't believe so, Your Honor. This isn't the hearing for the application to appoint receiver.
Okay.
He was available for the date that was originally set, but I think part of today's hearing is that the other side wants to reset it again.
Okay. We have a status conference on 2 cases, and it looks like a motion to consolidate on one of the 2 cases. Is that right?
Yes, Your Honor. That's my understanding, Your Honor.
Okay, let's go ahead and proceed. And do you want a record on this, whatever we're doing?
Yes, Your Honor.
On behalf of Mr. Holm, we don't need a record, but.
So, Tony, let's go on the record on cause number. We have 2 cause numbers we're dealing with today. DC 1918389 and DC 208643. When you're making your announcements, announce who you're representing and which cause numbers, if you're just doing one cause number, you're here on behalf of. Go ahead and start, Ms. Pettit.
Good morning, Your Honor. Julie Pettit on behalf of Mark Holm, also on behalf of 5 Star Global, and I am trying to pull up my case number momentarily. I'm not on the one with Mr. Null. So give me 1 second. the case number I'm here on is DC, well, it was DC 19-18389, but it is now DC 20-08643.
Okay, everyone else?
Good morning, Your Honor. Ben Reamer. I am here on behalf of Mid-Marketplace PBC LLC and Michael Knoll. And our cause number is DC-20-03925.
Morning, Your Honor. Cliff Riley on behalf of Edward Delgado, and our cause number is DC-20-07333.
Morning, Your Honor. Leslie Shigaris. I believe that my firm is involved in both matters, but I'll tell you, Your Honor, I just got involved on Friday. We represent 5-Star Global Defendants, David Lai, Drew Baggett, CCP Wolf Holdings LLC, and Paladin Capital LLC. And with me, Your Honor, is Jessica Lopez. She is our lead counsel for these parties, and she's going to be the one addressing the substantive issues today. Her admission for Pro Hoc is
I'm sorry, you said her pro-op was what?
it's pending. It's I think the court hasn't signed the order, but it has been submitted.
When was it submitted? Because we're usually pretty quick about that.
I believe it's been, Ms. Lopez might know better, but I think it's been pending for over a week. If you'll recall, Your Honor, this case was originally filed. She had been admitted into that case, and then when it got removed and refiled, we had to seek admission. So in one of the matters, it's been signed already, but in the one with Ms. Pettit's client, I believe it's still pending, but I think it's been on file for over a week.
Can you just email the order you want us to sign to Rhonda today, just so we make sure we get everything signed?
Yes,
Given
sir.
the kind of complication of moving between courts, I may not have seen it, so.
Yes, Your Honor, we'll do that today. Thank you.
Okay.
Good morning, Your Honor. You've got Katrina Ish on behalf of Southfield Mezzanine. I'm here with my co-counsel or partner, Scott Ahmad, and my colleague, Sarah Bayeski.
Okay, great. Let's go ahead and, that took a while. Let's go ahead and proceed. We're here on a motion. Why don't we start with the motion to consolidate?
Yeah, sure, Your Honor. So that this is Ben Reamer for Michael Knoll and Mid-Market. We went ahead and filed the motion to consolidate all of these cases after I think the court had first raised that issue of consolidation a few hearings ago. And we believe that consolidation for all these matters makes sense from a standpoint of efficiency, Your Honor. All the cases aren't identical. They don't have identical parties, but the cases are all related. There are overlapping issues in all of these cases, and there's certain to be overlapping discovery. We're already seeing that happening, frankly. 5-Star Global in my matter, in addition to bombarding my client with discovery, has also served a subpoena on Ms. Pettit's client, Mr. Holm. And so I think I think, for instance, Ms. Pettit's clients I can't imagine that they wouldn't be engaging in discovery in all of these different matters. And it's probably the same across the board. I've looked at the responses filed by Southfield and Mr. Delgado, and basically their position is, well, we're not parties to all these, so this is going to be less efficient for us to consolidate these cases. And I think that's exactly the opposite of the reality, because certainly we're going to want to depose someone from Southfield. In our case, we're going to want to depose Mr. Delgado. I would imagine that those folks are going to want to depose my client, Mr. Knoll. And so it's going to be more efficient to bring all these cases together. That's our position, Your Honor. This is the overarching issue of all these cases is a big, complex situation with a lot of parties, and we think it would make a lot more sense and be a lot more efficient to consolidate these matters and try to get some kind of a reasonable discovery plan in place for all of this, to the extent that we have the potential of having one deposition setting for some of these folks for the whole thing. We think that makes a lot more sense. And so you know, we're in favor of doing whatever. I mean, I'm certainly open to hearing what the other parties in all these disputes think, but we just want to do whatever is going to be the most efficient path forward, Your Honor. So we do believe that the cases should be consolidated.
Is Five Star a defendant in all of these different cases?
In my case, they are, yes, I think that they are a party. Five Star Global, I believe, is a party to all four.
Your Honor, they're not a party to the case involving Mr. Delgado, but Mr. Delgado is the CEO of Five Star Global. That's the only one in which Global itself is not a defendant, but their CEO is.
So would the idea be we're consolidating, what, 3 different cases or 4 different cases, or how is this?
Your Honor, I believe it's 3 different pending cases. The 4th one is the one that's no longer active because it went up to federal court and then was refiled here. So it's 3 cases.
3 cases, okay.
Your Honor, Cliff Riley on behalf of Edward Delgado. I just want to mention Mr. Delgado is sued in his individual capacity and is not the CEO of Five Star Global anymore.
Oh, he's not? Okay.
He retired. He's not currently the CEO.
Is that new information that the other side didn't know, or is that?
I believe
we knew that he was on his way out, but from what I can tell, he's still sending marketing emails on behalf of Five Star Global as recently as maybe last week. So I think that must be very recent, if indeed that is the case.
Okay. Anybody have a response to Mr. Reimer's suggestion? Somebody's sound is messing up. No response? Ms. Shigaris?
Yeah, Cliff, you want to go first, or should I for Southfield?
What? I can't hear.
Oh, maybe I'll try on. Okay, is that better?
That's better, yeah.
Is that better?
It is better, yes.
Can everybody hear me?
Yeah, we can hear you. Does anybody have a response?
Yes, Your Honor. Yes, I do. Again, Cliff Riley on behalf of Edward Delgado. Your Honor, we believe these cases should not be consolidated as to Mr. Delgado and Mid-Market. These cases are entirely different. They don't have any overlapping parties. They don't have any overlapping legal claims. They don't have any overlapping factual allegations. They arise from 2 entirely different factual predicates. Very briefly, Your Honor, the case against Mr. Delgado is just brought by Mark Holm, his holding company, against Mr. Delgado. It's based on allegations that Mr. Delgado made misrepresentations to Mr. Holm only, and that in a breach of fiduciary duty claim related to his acts as CEO. The Mid-Market case, Your Honor, is based on a private equity transaction that by which Caledon Capital through Five Star Global acquired the assets of Mid-Market Place. Your Honor, Mr. Delgado had nothing to do with that transaction. There's no allegations in Mid-Market's pleadings that he had anything to do with that transaction. And frankly, even as a witness, it's not clear how much value he would offer. And Your Honor, besides the fact that these cases do not arise from the same transaction, occurrence, subject matter, or question which is required in order to consolidate, the logistics and the efficiencies, as to Mr. Delgado at least, would not be obtained by consolidation. Your Honor, right now we have a pretty discrete set of claims against Mr. Delgado. It's a fairly complicated matter involving this private equity transaction. And if I understand Mid-Market's argument, it's that Mr. Delgado might be deposed in that case. Well, even if he is, Your Honor, if he has to sit for one extra deposition, the inefficiencies that Mr. Delgado would face in having to immediately educate himself on a number of claims and a number of issues that he was not involved in whatsoever, and then require his counsel, myself and my colleagues, to participate in many depositions and many hearings and many filings. For example, there's an application to appoint a receiver we have nothing to do with, took no position on, but these cases are wedded together. We're going to have to. So, Your Honor, as to Mr. Delgado, we do not believe that consolidation is going to create any efficiency. It's going to do the opposite. It's going to increase, it's going to vastly complicate the litigation, bring in areas that he's not involved in, give frank time that will bog him down. So for those reasons, Your Honor, we oppose consolidation to Mr. Delgado at the Mid-Market Place case.
Anybody else have a response?
We are also.
This is Southfield. Can everyone hear me now?
Sure, go ahead.
Okay, I apologize. I was having a technical issue. Your Honor, I represent Southfield Mezzanine Capital.
Wait. Mr. Tony, what's wrong?
I did not get his announcement and I can't understand what he's saying. What is your name, sir?
My first name is Scott, S-C-O-T-T. My last name is Ahmad, A-H-M-A-D.
Oh, I see. Okay.
Thank you. Your Honor, Katrina Eash and I represent Southfield Mezzanine Capital. We are a lender to one of the five-star entities, to the five-star group. And we are only in one of the cases. And in that one case, we are only a defendant to one count for breach of fiduciary duty relating to one issue about the provision of information. We have been subpoenaed in one of the cases. But again, as to us, we believe that obviously there's a lot of overlapping issues in the shareholder litigation. But as to us, there's only one small issue regarding the breach of fiduciary duty, and we're only in one count. And we've moved to dismiss that. That's up for hearing later in October. But we're proceeding, in this hearing with the understanding that, the case will go forward just for purposes of this motion. With respect to the practicalities involved, Mr. Reamer had said that we think that there will be a lot of efficiencies to be gained by consolidation because they're going to want to depose Southfield in their case. The issue with that is that if they want to depose us in their case, they can issue a subpoena for us, and I think they've already did, and then we would be deposed in our own case. But being a small defendant in one litigation, one lawsuit that's already broader in scope, and then if we have to participate in all the other cases, then we've got to attend all those other depositions and all the other participate in all the briefing and all the other cases, and it substantially increases the workload that will be in our attorney's fees as well. And we've cited case law in our opposition that that the prejudice to defendants to having to participate in that is something that is a basis to deny consolidation. And so to the extent that there is a consolidation of some of the cases, we would humbly ask, Your Honor, that our case be excluded from that for all of those reasons.
Your case is five-star defendant in your case?
Yes, Your Honor.
Okay. Ms. Shigaris, you've been trying to speak for a while. I apologize. Why don't you go ahead and go next?
Obviously, the five-star defendants are in two of the three actions, but I think we have some real practical concerns of even if we were to consolidate it, issues that I think will right across all of the claims. Ms. Lopez.
I could barely hear you. Could you hear her, Tony?
It was pretty choppy.
Oh, I'm sorry. Did you say you wanted Ms. Lopez to speak next?
Yes, I apologize.
Okay, go ahead, Ms. Lopez. I can't hear you at all, Ms. Lopez. Usually Zoom works pretty effectively, but it's not doing too well in this hearing. Ms. Lopez, did you want to say anything? Sorry, Ms. Shigaris, you may have to speak on behalf of Ms. Lopez. I'm not sure what's going on with her computer. But is no one's, wait. I can't hear Ms. Shigaris.
Can you hear me, Your Honor?
Yes. Ms. Pettit?
That was me. I was making sure you could hear me. I do want to comment, but I'm not going to cut them off. Hopefully they can get their sound working.
And can you guys hear me also? This is Scott, Ahmad.
Yeah, we can hear you fine.
Okay.
We just can't hear Ms. Shigaris or Ms. Lopez. Ms. Pettit, while we're waiting for them to get their stuff fixed, did you want to respond?
Yes, Your Honor, just briefly. I think based on the fact that we do already have a number of cross subpoenas going between the parties, I think that's further evidence of the overlap and likely continued overlap. I didn't join in this motion, but just from a practical standpoint, it does seem to me like it would be more efficient for the court and for the parties to have it joined. The only thing I would like to comment.
Let me just say this, and so you can kind of frame your comments, and Mr. Reimer can discuss this too. I'm kind of inclined to have the two five-star cases together. I'm persuaded that maybe the Delgado case, at this point at least, is not appropriate for consolidation.
Sure.
And so
That was what I was about to take issue with the statements from counsel for Mr. Delgado, because I just disagree with the factual statements that and the representations that he made to the court. Specifically, Mr. Delgado is front and center of this issue. To say that he was not involved in the equity transaction is completely inaccurate. In fact, my client paid for equity for Mr. Delgado to have a piece of the company as part of this equity transaction.
is Mr. Delgado a defendant in either of the 5-star cases?
No, Your Honor. So he received an equity piece that was purchased for him by my client as part of that transaction. But more importantly than that, a big part of the 5-Star Global case is Mr. Delgado's attempted firing of my client, Mr. Holm. And as part of that, I think Your Honor has already heard about that in previous hearings, that Mr. Delgado and Mr. Holm obviously have a dispute about what happened. My client states that he was fired about 6 months earlier than I think Mr. Delgado will admit that the firing took place. And so this particular firing, the date of it triggers a number of different things that will become very important by way of the operating agreement and the 5-Star Global cases, because that triggers buyout provisions and things of that nature. So to say that Mr. Delgado is not involved is inaccurate, because he's front and center of this firing that took place on a certain date and triggers these other deadlines, which will be impacted, which will impact greatly the issues in the other case.
Let me, Ms. Shigaris.
Can you hear me better now, Your Honor?
Yeah, much better. I can actually
Okay,
hear
great.
you. Okay.
I apologize for that. I'm not sure what happened. I think Ms. Lopez fixed her sound too, but let me just say one issue that I think hits on where Your Honor is, the concern is. We wouldn't oppose if there was, and I think the party should work together to come up with some kind of discovery plan where there is overlapping issues, because I think that there will be, as already referenced, subpoenas in the other cases. But I think we can do that without consolidating the cases, which gives some practical concerns. For example, in one case, there's a bench trial. In another case, there's a jury trial. And so, and I do want Ms. Lopez, she's going to talk about why in our cases they aren't substantially similar. They arise out of separate transactions.
Ms. Shigaris, let me tell you where I'm leaning towards it. This is not a ruling, but what I'm leaning toward is consolidating the 2 5-star cases for the purposes of discovery, make a determination at trial if there should be separate trials or joint trials. And I haven't made a decision on that. I would. And then as to the Delgado case, I would probably want to see if there's going to be a receiver appointed. And then if there is a receiver appointed, ask him or her if they would like, if they think the Delgado case would it be more efficient for their operation of the receivership if the Delgado case was part of this or not. And they may not have an opinion, but I'm kind of inclined not to have Delgado in this, at least at this point, but maybe, so that's kind of where I'm leaning, because I if this was my only case, I would kind of see what you're saying, but I think that there's just going to be so much overlapping discovery and hearings, and I just think it's more efficient to conduct the discovery together and maybe hold off to make a decision on whether or not to try these cases together. So does that address your concern or no?
It does. I would like, if the court will allow Ms. Lopez to explain some of the differences between the 2 causes. And I think why that's important, Your Honor, is if we consolidate all of these, even just for discovery purposes, now you're looking at 6 hours of deposition per side. And I think the per side basis is going to be complicated. And now we have very distinct issues and 2 different cases where we're now going to be much more limited on the amount of deposition time. So those may be things we can work through, but I think that is something that concerns us. So if you'll indulge us and let Ms. Lopez give you some background on the 2 different transactions that these cases arise from, maybe we can just craft something that addresses all the different competing issues.
Ms. Lopez, is your sound working now?
Can you hear me, Your Honor?
Yeah, all right, we can hear you now.
Usually I have more success with Zoom here, so I apologize. And thank you, Your Honor, on these very important issues. I'd like to maybe start by telling the court how my client, my main client, 5-Star Global, is involved in these 3 lawsuits, if at all. In the Mr. Delgado lawsuit that Ms. Pettit has brought, 5-Star Global is not named as a party. In the home and 5 Points holding lawsuit that Ms. Pettit has brought on behalf of her clients, 5-Star Global, along with 7 or 8 other defendants, including Mr. Ahmad's client, Mezzanine, are named defendants. In the lawsuit that my client initiated as a plaintiff against Mr. Reimer, it is, of course, the plaintiff in that case, and Mr. Reimer's client is Mr. Null, as well as Mid-Marketplace Alliance defendants in those cases. So hopefully that addresses the role of 5 Global in the 3 matters. And putting aside the very practical implications that Ms. Chagaris raised with respect to a trial by bench in the matter that Mr. Reimer is handling, as Your Honor might recall, before this case was transferred, Judge Redden granted 5 Global's motion to strike jury demand. And absent disturbing that order, the case between my client and Mr. Reimer's clients will proceed to a bench trial. Conversely, the case that we are now handling with Ms. Pettit will proceed to a jury trial. Both the petition and the counterclaim that were refiled just recently last week both contain jury demands. So even if consolidated, these cases cannot and most likely will not try together. From a pre-trial and discovery perspective, if the cases are consolidated, we don't think that there's really going to be any great efficiency. I agree with Ms. Chagaris. I don't think anyone is disagreeing that we should try to work among counsel to find the best way to move forward efficiently with all these cases, but consolidating them is going to probably be a significant issue because dealing with 6 different law firms who may need to attend depositions and ask questions on behalf of their clients, some of whom may not necessarily need to be in attendance at the depositions if they weren't consolidated. And from a party resources perspective, Your Honor, I think it's also important for the court to understand that some of the lawyers on the various cases are being paid under a single wasting insurance policy, such that if they need to be present at depositions from a consolidation standpoint, we're actually talking about wasting the party resources under that single policy. But I'd like to just spend a few brief moments talking to the court about the differences in the transactions underlying the case with Ms. Pettit.
Let me just ask a quick question. Ms. Reisinger, do you guys still need, or Ms. Newman, I'm sorry, or Mr. Westmoreland, do you guys still need your 11 o'clock hearing, or are you guys passing that?
We do still need our hearing, Your Honor.
All right, I'm sorry, Ms. Lopez. I know you've had some technical difficulties, but we're kind of out of time. So I'll give you another 30 seconds.
Thank you, Your Honor. Just briefly, the transactions in the Mr. Holm lawsuit and the Mr. Null lawsuit are entirely separate. One closed in May of 2018 with FSG, Mr. Holm, and 5 Points Holding. The other one in Mr. Reimer's case didn't close until January of 2019, dealing with entirely different assets, entirely different business. There is no relationship whatsoever between those 2 asset purchase agreements or any relationship between the accompanying employment. And as Your Honor knows, there are various employment issues at play in both lawsuits that are very distinct. That's because Mr. Holm and his entity are voting members in the entity that I represent, whereas Mr. Reimer's clients are non-voting members. Additionally, Mr. Holm held a position of superiority and power as a chief creative officer, whereas Mr. Null was simply a principal. And so there are varying degrees of fiduciary obligations, varying and distinct issues arising under the employment agreements, and very separate transactions that are in no way connected to each other. So therefore, Your Honor, we would request that the court not consolidate these matters at this time.
All right, Mr. Reimer, Ms. Pettit, this issue involving the wasting of the insurance policy, I guess, could be kind of a concern to y'all. I don't know how that plays into your requests for consolidation. If you had 2 choices, Mr. Reimer, Ms. Pettit, either I'm going to consolidate the 2 5-star cases, not consolidate at this point the Delgado case, only consolidate for purposes of discovery at this point, and then make a determination at trial if there'll be separate trials or the same, or just keep them all separate. What do you prefer, Mr. Reimer?
Yes, Mr. Reimer and Your Honor.
I'm sorry, Mr. Reimer. I apologize.
No problem, Your Honor. I think that I think that makes perfect sense. I don't have claims directly as between Mr. Delgado and my client. I will echo Ms. Pettit's sentiments that the representations that Mr. Delgado isn't involved in all these things is completely false. And when you read, for instance, the application for a receiver, it's clear how involved Mr. Delgado was in all these things. As one example, similar to Mr. Holm, Mr. Delgado was actually the person who terminated my client, which is a very important issue in the case. So we fundamentally disagree that Mr. Delgado wasn't involved in all these things, but I don't have claims directly as between my client and Mr. Delgado. I think the court's suggestion of just consolidating all the cases involving Five Star Global prior to appointing a receiver makes absolute sense.
Ms. Pettit?
Yes, Your Honor, just briefly. I believe that the two Five Star Global cases should be consolidated. Ms. Lopez's representation that the two transactions are completely separate is inaccurate as well. I know that Ms. Lopez and Ms. Shigaris weren't on the previous hearing, Mr. Bexley was, but as I explained in that particular hearing, their clients didn't have the funds to buy Mr. Reimer's client's company, so my client fronted all of that money. So Mr. Holm is the one that paid for the very transaction that's now in litigation between Mr. Reimer clients and Ms. Lopez client. So to say that they're not related is inaccurate because my client paid the bill for the purchase of that company. So I think they should be consolidated. Those two certainly seem to be more in line with one another than Mr. Delgado's, so I agree with that. I don't agree that Mr. Delgado was unrelated, but I do think the two Five Star Global cases are certainly more aligned than that of Mr. Delgado.
Okay, so what we're going to do is we're going to consolidate the two Five Star cases for purposes of discovery. I want to include in the order that the court is deferring the decision of whether or not to try these cases until the time of trial. So there is a possibility it'll be separate trials, especially if one has to be jury and one has to be non-jury. And then for the Delgado case, I want to go ahead and just defer that as well, and until I get a recommendation from the receiver if a receiver is appointed. So go ahead and get me an order on that. Go ahead.
The other issue is we had the receivership hearing set for next week. I think Ms. Lopez or someone on their team had called to inquire about different dates because they wished to move the dates again, and somehow the court's calendar was actually switched to a date that we're not in agreement with. Ms. Shigaris and I spoke yesterday, and we'd like to see if the court can once again accommodate and try and pick a date that works for the other side.
Okay, so I'm a little confused. Wasn't it set for this? Was it set for this Thursday? And then somebody told us they needed to cancel that. I thought, isn't that what we had agreed to? Am I remembering that correctly?
We had agreed to that, Your Honor, and it was not my side that canceled it. We did not call the court or have any communication with the court.
Who told the court that that was supposed to be canceled?
Your Honor, this is Leslie Shigaris. I don't believe that it was said that it was supposed to be canceled. What happened was after the hearing was set on October 1st, Your Honor may be aware, but Ms. Lopez has had some health issues that have required some medical surgeries. She is now set for surgery on October 1st, which was not known at the time it was set. We worked with Ms. Pettit before we called the clerk's office to see if we could reset it by agreement. She agreed that we could reset the hearing in light of the conflict if we could get something in a short amount of time. We were told, everyone said, we could be available maybe the next week or the following week, but the court did not have availability. How it actually got switched to the 26th, I'm not sure. We were told the next available date was the 26th. I called Ms. Pettit to let her know and see if we could work out that, or see if we could find a sooner date if Your Honor could fit us in sooner. How it got changed on the docket, I'm not sure, but I believe that was by mistake, and I alerted that Ms. Pettit to that issue as soon as I saw that it had been changed on the docket.
How about September? Why don't we just do it this Wednesday at 2 o'clock? That would be before Ms. Lopez's surgery.
Your Honor, this is Jessica Lopez. The parties had met and conferred last week concerning the preparations for this hearing, and with all due respect to the court, I don't believe that we will be able to accomplish all that we had contemplated under the Rule 11 agreement, including the exchange of exhibit lists, witness lists, issuing subpoenas if necessary, sending exhibit binders to the witnesses who will be testifying. It's going to be a substantial evidentiary hearing that we would ask the court to reschedule after the first, if at all.
Your Honor, may I speak briefly?
Sure.
This application to appoint receiver has been on file since May of this year. It's now obviously almost October. Both parties have submitted affidavits. A few additional facts have changed since that time, but if the scheduling is going to be that difficult and we've been waiting this long, I would respectfully ask that maybe we do it by affidavit so that we don't have to worry about their scheduling issues. Everyone's filed affidavits. Perhaps we can have a little bit additional briefing and let Your Honor decide based on submission, because at this point, we've been trying to get this done since May, and I believe every single day that this is being delayed is impacting negatively my client and Mr. Reimer's client.
Your Honor, I understand that Ms. Pettit wants to get to a hearing, and it is not our intent to delay. That's why we just requested a 1 week further. One of the concerns is we had agreed to exchange objections 3 days in advance. We would not agree to do this by affidavit or submission only. The issues of appointing a receiver are very, very critical to the health and continued health of this company. And I know there's a secured creditor that I understand will also be objecting to the court's appointment of a receiver. So I am available on Wednesday. The problem is just making sure we get all of the objections in advance, and we will need to have some live witness testimony, including from our own client.
It's just a scheduling issue to me. I mean, I can do this Wednesday. Next week is problematic because, as you know, we've delayed jury trials, unfortunately, due to the pandemic. And next week's a non-jury week, and it looks like I have a lot of cases set next week. And so you're asking me to fit in a 2-hour hearing. I wish I could just pick a date that everyone's going to be happy with. Ms. Chigueras, would you rather go on Wednesday, or Ms. Lopez, and have an evidentiary hearing, or would you rather do it by submission and we can schedule it some other time?
I'll have to defer to Ms. Lopez because she's the one that's familiar with the witness testimony that we would intend to put on.
Your Honor, I think that it's important for you to hear from the various clients, including Ms. Pettit's client, particularly on cross-examination with respect to the allegations that are central to the application to appoint a receiver. And as Ms. Chigueras said, this is a very significant—
Ms. Lopez, you had two choices. I don't mean to cut you off, but I have a lot of other hearings I got to get to. Unless Ms. Reisinger, have you guys worked out your differences? Do you still need a hearing?
I don't think we'll have to resolve the controverting affidavit ourselves, Your Honor.
Your Honor, I'm fine with you doing this by submission if Ms. Reisinger prefers. My response is on file. I don't have any argument beyond what's in the response.
Ms. Reisinger, what do you think of that?
Your Honor, I'd be fine with that as long as I could do a quick one-page reply to the reply today, if that would be all right.
I'm fine with that, Your Honor.
I'd rather just hear argument. To be honest, I'd rather just hear argument. So, Ms. Lopez, do you want to go this Wednesday, or you want to do it by submission?
Your Honor, we cannot practically go on Wednesday as a result of the Rule 11 agreement. And so if the only option before us as a result of my surgery is to forego an evidentiary hearing or submit on affidavit.
I'm not preventing you from doing evidentiary hearing, and I'm not a part of this Rule 11. You can have a hearing on Wednesday, an evidentiary hearing. No one is preventing you from having an evidentiary hearing. Ms. Pettit, will you be willing to change whatever deadlines are required under the Rule 11 to accommodate this hearing on Wednesday?
Yes, Your Honor. I submitted the Rule 11 to the other side. It has not been signed and returned to me. So as far as I'm concerned, we don't actually have a Rule 11 that's binding and in place at this point. But yes,
so Ms.
I'm
Lopez,
certainly willing to move any deadlines.
Okay, Ms. Lopez, do you want the hearing on Wednesday, or do you want to have it by submission?
I'd ask that Southfield Council, Your Honor, also weigh in because they are a party to the receivership application. But I don't understand how we can have a hearing on Wednesday, so we would have to submit on affidavit. There's no way that we can get all of our exhibits sent to witnesses and counsel across the country, change exhibit and witness list. I've already issued objections to Ms. Pettit on her exhibits, and I would like to meet and confer with her on those. I'm still waiting on objections to confer on our information. And so there's just a lot to be done before a hearing that cannot be accomplished in 2 days, Your Honor, unfortunately.
Yeah, Your Honor, I agree, and just very, very respectfully, I just don't think that's enough. No, I mean, I personally have a deposition on Wednesday. Obviously, we were going to be prepared to go on Thursday or the week after. I would think it would be very prejudicial to have to do it within 2 days. It's an important issue. I mean, as you know, a receiver is one of the most drastic remedies provisionally speaking, that can be entered, and we filed an opposition, but I would join in Ms. Lopez's request that there be a full evidentiary hearing set at a later time over the next couple weeks, if we could please do that.
Your Honor, when Ms. Pettit and I spoke yesterday, it's been already moved to the 26th by some mistake, and I don't know how that happened. What I thought our discussion was—
That's the next available date. That's the problem. So
that date works for us. I understand that might be too far for Ms. Pettit, but respectfully, we would, given the significance of the issues, we would ask for the evidentiary hearing on that date.
Yeah, and I do think, Your Honor, from what I've seen from the communications, Ms. Pettit and Ms. Chagres did talk yesterday and said, let's find a date that works for everybody. And, now all of a sudden it looks like she's just, to gain a tactical advantage, just rushing everybody to the table on Wednesday. I don't think anybody, including her, would be prepared by Wednesday. I think that it's totally tactical. And she said yesterday that she would agree to a date.
This isn't Ms. Pettit's fault. It's an issue of the court's calendar. So this was originally scheduled on Thursday. Nobody raised this issue of the surgery when we first discussed it. Apparently there's a surgery that's come up. I'm trying to accommodate Ms. Lopez so that you don't have this on Thursday. I want to be able to do it before her surgery. I'm really trying to accommodate her. But I also have to accommodate the over 1,200 other cases on my docket, and the fact that I haven't been able to try jury cases in over 6 months. I wish that I could do everything possible to accommodate everyone's schedule. I'm sorry that you guys might have to work kind of a little harder the next 2 days, but I really am trying to accommodate Ms. Lopez here and her surgery. And so she has local counsel that could handle this on Thursday. Ms. Chagres is very able. Weren't you just named the DAYL Outstanding Young Lawyer, I think, and if I heard that correctly, is that right?
That's right. I'm just glad they still call me a young lawyer, Judge.
Yeah. I mean, she's a very able counsel. I think she could probably, you've handled numerous receivership hearings in my court, haven't you?
I have, Your Honor, and the issue would not, typically I would just step in and do it. It's that literally Friday was the first time that I had any involvement in this case. So I just don't, I'm there. I will do everything I can to get up to speed by Wednesday, but I haven't even had a chance to read the pleadings yet. I just got information yesterday from Ms. Lopez. So otherwise I would take advantage of that and I could handle that, Your Honor, without any issue. But I am at a disadvantage having just gotten involved in the case.
You are very familiar with how I handle receiverships.
Yes, Your Honor.
In fact, you actually worked with Mr. Buchanan on my last receivership with him. Isn't that true?
That is correct, Your Honor.
So you're very not only familiar with this court, with receiverships, how this court handles receiverships, you're very familiar with how Mr. Buchanan handles receiverships. Is that correct?
Yes, Your Honor.
I'm sorry, Mr. Ahmed. I really am a bit offended about how you tried to say that this is tactical. Ms. Lopez, we're trying to accommodate Ms. Lopez's surgery. And so moving up a day doesn't seem like it's that big a deal to me. I'm glad to do it in the afternoon to try to give you guys extra time, each give you an hour to argue this. But I have to also look at my other 1,200 cases. So no one is trying to be unfair to Ms. Lopez. We're trying to do everything possible to accommodate her. If it's not a big deal to Ms. Pettit, I'm glad to put this on the 26th, but that's my next available date according to the clerks.
Your Honor, would you mind, because I know you have other hearings, if after this call, Ms. Pettit, Mr. Ahmed, Ms. Lopez, and I could get on the phone and we will take you up on either doing the 26th, keeping it on the 1st, or moving it to the 30th. But that will give us time to, one, make sure that, we need to make sure that Ms. Pettit's clients will be available for cross-examination and just work through those three options, and we will let the court know.
Why don't I do this? I'm going to put you into a breakout room, you guys into a breakout room so you guys can talk. I'll send one of my interns with you who can text me when you're done. and then I'll bring you guys back so that you have a chance to kind of talk.
And just before we switch rooms, I want to be clear that my office is not available on the 26th. So unfortunately, that's just not an option. Either myself or Mr. Urtiago, either of us who could argue it, neither of us are available. We both have conflicts in other cases on that day.
Then it would be sometime in probably mid to late October before we could hear this. So just be aware of that if whatever you want to agree to.
Your Honor, this is Mr. Reamer. Is as far as the time on Wednesday, did Your Honor already state what time? I have a separate hearing at 1:30 on Wednesday, which I don't think will take too long, not more than half hour or hours.
I could do the morning, or I could do 1:30. Those are the times I'm available on Wednesday.
Okay, we would prefer morning in that case on Wednesday.
Okay. Well, why don't you guys?
Your Honor, I apologize. It was not my intention to offend you. I don't know the nature of her surgery, and you know, obviously the day before and doing that, but I don't know what prep's involved in the surgery, and I was just trying to be sensitive to Ms. Lopez's needs. It wasn't and I just had a different understanding of the conversation that occurred where I thought we were going to pick a date that was convenient for all counsel. It wasn't my intention to offend you, and I apologize about that.
That's okay. If you want to contact my court clerk and while you're on your breakout room and figure out a different day, I'm just going on what they're saying. I know that I could do this Wednesday because I have I think all of the cases I have set tomorrow are jury trials. We're definitely not doing jury trials this week. And so I know that I could do Wednesday. So, but there may be some other date that some hearings been canceled or whatever. And I'm okay with moving it to a later date if you guys all agree. But I really am trying to accommodate everybody. So.
And I appreciate that, Your Honor.
All right, so let me go ahead and create a breakout room. Ms. Munder, I'm going to go ahead and send you with them, and then text me whenever they're done, okay? And I'll bring you guys back.
Thank you.
All right, Mr. Reamer. Is Cliff supposed to go on this one? Who's Cliff?
Your Honor, that's me, Counselor Mr. El Delgado.
All right.
I do not need to be involved.
I'm going to send you anyway, so
okay.
You're involved in these cases. Ms. Munder, Ms. Pettit, Ms. Shigaris, Ms. Lopez. Am I missing anybody? Mr. Ahmed. Who?
Miss Ish.
Ish, K. Ish, okay. Anyone else? Is
Ms.
Sarah Krajewski, is she supposed to go too?
Yes, Your Honor.
Yes, Your Honor.
How about Tamara Brock? No, she's on another case, I think.
No, I'm not. Yeah, exactly. I'm still here.
Farnaz, which case are you? Are you here? You need to go into the breakout room?
No, sir. I'm here for Wayne versus Worku.
Okay, I think, did I miss anybody? Mr. Nall, do you need to go into the breakout room?
Mr. Nall is my client who's been observing.
Okay, so he needs to go too then. Did I miss anybody?
No, Your Honor.
I think you've covered everyone.
All right, and I'm sorry, did I get Miss Munder again? Text me when they're done, okay? Okay, all right, Ms. Reisinger, I think you're it's been a busy morning, I'll just say that.
Yes, Your Honor. I'm ready to get started if you are. I'll try to keep this as quick as possible.
Sure.
And I will apologize. I'm at a site inspection. I thought I was running short on time, but I had more than I thought. So I'll get started. This is a car wreck case. We had Gregory Lachar offer a controverting affidavit as to emergency room treatment that was received by the plaintiff immediately after the incident occurred. We have moved to strike that controverting affidavit for a couple of reasons. First of all, this ER doctor is not a radiologist. The provision of radiology services at the ER were by radiologists. Therefore, in order to controvert, there needs to be a matchup of qualifications under Turner v. Peril, and Lachar is not qualified. Next, Your Honor, this is on file, I believe, on 6/1/20, but I also have the wonderful Rebecca, who's available to share screen so that we can actually take a look at the affidavit itself, if that's all right.
Sure, let me go ahead and, sorry, just give me 1 second. Okay, yeah, there she is.
So like many controverting affidavits, this, while the affidavit is about 4 to 5 pages, most of it is just a medical summary, not actually analysis. In this case, these paragraphs are the entirety of the actual analysis as applies to the bills in this case, particularly if you look at 19, that's the most that we get as to the discussion, paragraph 19, that's the most we get as to the discussion as to the charges themselves. For this reason, Your Honor, we ask that this affidavit be struck because it's simply bare bones. It's not going into detail. And one of the issues about this case is that this affidavit that is attempted to be controverted by the defendants is not even just for these two charges, the ER charge and for the facility charge and the x-ray. It also includes a whole other visit in March that's not even commented upon by this expert. He doesn't even talk about it. He controverts other things like pregnancy tests, when radiology exams are going to be done, which clearly any medical provider could understand how that's important to do before you do a radiology on a female plaintiff. And that's not even commented about. All we get are these very bare bones conclusory statements with no explanation. And for those reasons, we ask that the controverting affidavit be struck.
Okay. Response?
Your Honor, Dr. Lacker addresses 3 things in his affidavit. He addresses the fact that he doesn't feel this should have been a level 4 emergency room visit, that it should have been a level 3, and he provides adequate explanation for why he reaches that conclusion. He also addresses the CT scan of the cervical spine. While he does talk about pricing in paragraph 19 on the screen, more importantly, prior to that, he says he doesn't feel that the CT scan was warranted at all. He explains why that's the case. He actually quotes from the emergency room physician, whom himself in the record said there was no need for a CT scan or other type of cervical radiology, and yet it was performed. And so I think he's clearly stated his basis for drawing that conclusion. The only other thing that this emergency room doctor addresses with respect to this emergency room treatment is I believe a chest x-ray. He says that it should have cost $400. It cost $430. So we're fighting over $30 there. So, Your Honor, it's pretty basic. We have an emergency room doctor addressing emergency room treatment. He says it should be level 3, not level 4, and gives his explanations for that.
I just have to ask this because I was wondering, why did you file a counter affidavit on this? I mean, it seems you're fighting over so little. Why'd you even file one?
Well, again, there's some difference between the cost of a level 4 versus a level 3.
$30. Oh, I'm sorry, because of the CTs, I guess.
That's right. And then there's the CT scan issue as well. So, I mean, and I don't remember exactly how much was billed at this particular time. And Plaintiff's counsel is right. There was another visit that he did not address at all. And so I don't think that's an issue here before the court, and not sure why Plaintiff's counsel would complain about that. He only controverted the level 3 versus level 4.
It kind of seems like this is an ideal case for dueling affidavits, but Ms. Reisinger, I kind of have a vague recollection from a previous hearing your firm doesn't agree to those, or am I wrong about that?
Yes, Your Honor. We don't agree to dueling affidavits on this case, and if I would like clarification, because if at least if we can clarify that this controverting affidavit is only controverting the dates of service for the dates that are actually addressed, because the way that 18.001 is phrased, we would have to bring an ER doctor for everything instead of only dealing with a small portion or having the election to not bring up those bills and have to get a whole new affidavit. And so since there's much other issues addressed in that affidavit and the whole thing is basically null with a controverting affidavit not struck, we would request that at least an order clarifying the exact matchup of what's being controverted in this case.
Response to that?
I mean, the only thing I would say, Your Honor, is obviously all we're trying to controvert is what he mentions in his controverting affidavit, which, as I've said, is the level 3 versus level 4 emergency room visit, a $30 difference in a chest x-ray, and the reasonableness and necessity of the CT scan of the cervical spine. That's all. And so if plaintiff's counsel wanted to craft an order that makes it clear that that's all that's being controverted, certainly we concede to that. That's all he addresses in his affidavit. We weren't attempting to controvert anything else.
And Your Honor, if I can briefly respond.
But Ms. Reisman, let me just kind of give you one thought to think about. And I don't know if Ms. Newman is here also. I don't know what her role in this is, so she can chime in as well. I guess my thought is that this is probably an adequate emergency. I mean, probably an adequate counter affidavit. It's very limited on what it's countering. And so if I deny your motion to strike the counter affidavit, then you'd be forced to call someone from the emergency room, I guess, to testify, which would seem to be a lot more expensive. Since it's so limited, and I'm sure there's some reason why Mr. Westmoreland, he's a very good lawyer, filed a counter affidavit on such a small amount of money, whatever reason there is for that. Having a dueling affidavits where he says it shouldn't be level 3 and it should be $30 cheaper, and you say this is what it keeps you from having to call the doctor live. It just seems like that would make sense, but what do you think?
Your Honor, if it's the question of having to call an ER doctor or having to have a dueling affidavit for this specific case, I can understand that. So, but I think that that's something we generally don't agree with, because the affidavits go so much broader onto other topics than just discussing those paragraphs. And it would include us having to agree to the submission of the entirety of the medical summary as put forward by the defendant and their hired witness. So there's a couple of issues for why.
What if we did this? What if I sent you two guys, you and Mr. Westmoreland, and I guess Ms. Newman as well, if she wants to go, to a breakout room, and you guys can discuss exactly what would. I agree, Mr. Westmoreland, there's a lot of stuff in there that doesn't need to be in there for a counter affidavit. And so if you're doing dueling affidavits, you should redact the stuff that's really superfluous.
Which I'm perfectly fine with, Your Honor. I don't need to be in a breakout room to come to that agreement. I can agree to that right now. There's just those 3 points that we were trying to controvert, and to the extent that there's superfluous comments about other things, we can agree to redact that portion of the affidavit for purposes of dueling affidavits. And I guess financially it makes sense to do so, but that's not my call. That's up to Ms. Reisinger.
If we can come to some agreement as to reduction of other portions and keep those points in on those paragraphs we've been discussing, then I think that's fine.
Your Honor, if you don't mind, I know that your hearing takes precedence, but I do have a few other attorneys waiting on me to resume a deposition that I had started earlier this morning. What I would ask is that when she gets the opportunity, when she gets back to her office or so forth, that Ms. Reisinger just send to me a version of a redacted affidavit that she proposes. I'm certain that we can reach an agreement on that, she and I, but it may take a little bit of time to get that worked out. I'm thinking, especially for her to be able to take a look at it and modify my expert's affidavit the way that she would like it to look. But
why don't we do what, Ms. Reisinger, which time are you going to get back to the office?
I still have another 30 minutes here, and then I can get to it immediately. I know exactly what I would.
Could you guys come back at 3:30 if you needed any additional assistance, or would that work for you or no?
I'm sorry.
Brad and I have worked really well together. I would be shocked if we couldn't get things worked out, but it sounds like he's got a busy
just trying
day,
to give you some additional time. So,
Brad, I don't know what you think, but I think we'll be able to work it out. But I don't know what your time schedule is.
I would just say these other attorneys in this other case are being very patient with me, and I still have 2 other depositions with them starting this afternoon.
Okay.
I'd rather not test their patience.
How about could you come back tomorrow morning if you needed, or however you want to do it? If you feel like you can work it out, I'm just trying to give you an accommodation. So if you don't need any additional time with me, I'm okay. I'm just trying to give you times when I would be available. So I could meet with you 3:30 today or tomorrow at 9. But if you don't need it, then you don't need it.
Tomorrow at 9 is fine, assuming that there's an exception where we can't work it out. But hopefully, I'll contact and let you know that we worked it out.
And if just let us know, Ms. Reisinger or Mr. Westmoreland, just if you work it out, email my court coordinator and say you don't need the hearing time. If you do need the hearing time, email them and say, hey, we need the hearing time at 9 in the morning, and we'll work it out then.
Thank you.
Good to see you guys. Bye-bye.
Thank you. Alex, I'll look at it as quickly as I'm able.
Great. Talk to you soon.
Thank you. Thank you, Your Honor.
Okay. So let me ask this, guys. So I want you guys to kind of talk to yourself. You're on YouTube at the moment, so I know there may be some confidential information that's going to be discussed during this hearing. What I would suggest you do, because I try to make this as much like a courtroom as possible, I'd suggest you guys go back to the back conference room to discuss among yourself if this hearing should or should not be on YouTube. I need to take a break. I haven't had a break all morning. And then when I come back, we'll make a determination of whether or not this hearing should be on YouTube. Okay?
Okay, Your Honor, are you going to send us to another room again, or?
No, I'm just going to leave you in here, unless, who's Mr. Scott? Is he for something else?
Yeah, he must be. I don't know Mr. Scott. Oh,
Mr.
Juanita Scott is our client.
I'm
that's
sorry.
the maiden
Okay,
name.
I didn't.
Yes.
It's just Jay Scott. I apologize. So, but
Yeah.
I'm going to turn YouTube off now, and then you guys discuss amongst yourself. Do you want me to send you to a breakout room? Would you feel more comfortable with that, just in case? Because there will be.
Yeah, I mean, no, I think we can discuss it because we already had preliminary discussions about how we were going to reference everybody, so yeah, but I think that we should have a general discussion. I think we're okay doing that on YouTube unless someone else, Robert, do you have any thoughts about
guys,
that?
I have to take a break. So
Okay.
do you want me to put you in a separate room or not?
Your Honor, no, you don't need to put us in a separate room.